Right, good morning everybody. The time is now just after 10 o'clock and this inquiry is open. First of all, can everyone switch off their mobile phones or turn them on to silent? Hopefully everybody can hear me. We have microphones in the room, so if all participants can you please use microphones when you're speaking and then turn them off when you're not. That would be very helpful, thank you. So my name is Helen Harkenhall. I'm a Chartered Town Planner and have been appointed by the Secretary of State to hold this inquiry. The inquiry is into an appeal made by Lee Huff & Co. under Section 78 of the Town and Country Planning Act 1990 against the refusal of outline planning permission by Chorley Borough Council for the erection of up to 123 dwellings, including 30% affordable housing, with public open space provision, structural planting and landscaping, with vehicular access from Grange Drive. The site location is land adjacent to Blainscough Hall, Blainscough Lane in Coppull. First of all, a few housekeeping things. Can the council please explain the emergency evacuation procedures, or is there a fire drill today?
Yes, thank you, Madam. There is no fire drill scheduled for today, so if the alarm is ringing, it's a real emergency, and officers will direct everybody to exit the building if we go through that door and then to the right.
Okay, thank you very much. One minor point as well. I believe I was informed this morning that the chamber has been refurbished quite recently, so all drinks, can you use the coasters, please, and then you don't damage the surface of the table. So I won't remind you again, it's just a minor point. Thank you, everybody. Right, so first of all, it is really great that we are able to hold this inquiry face-to-face. As most of the professionals in this room will know, we've been working virtually for around 18 months or so. It's actually quite nice to have an inquiry and have people in person rather than looking at a screen, though unfortunately I have a screen in front of me here so I can see myself, which is a bit disconcerting, but never mind, I'll get used to it. Right, and of course just a reminder about the normal restrictions, COVID restrictions, keeping separation distance, hand sanitising, and certainly if anyone is not feeling well, then please don't come to the inquiry. If we do have any situation where parties aren't able to proceed for whatever reason, we do have the option of reverting back to the virtual format. So I'm sure we'll be able to do that. Hopefully that won't be necessary. We'll be able to continue as we are today, face-to-face here in Chorley. Just also a reminder, the event is being live streamed by the council today on the YouTube channel. So just a reminder for everybody about that. So first of all, I'd just like to take the names of those who wish to speak today. Firstly, for the appellant.
I appear for the appellant. My name is Cannock, C-A-N-N-O-C-K, initial G for Giles. I'm Queen's Counsel, instructed through the scheme of direct professional access by Mark Saunders. I have three witnesses. Mark Saunders, who splits his evidence between housing, land supply and planning. Neil Tatton, T-A-T-T-O-N, dealing with affordable housing. And John Powell, P-O-W-E-L-L, dealing with the education contribution.
Okay, thank you very much. And for the council, please.
Madam, that's me, Ian Ponter, P-O-N-T-E-R, a barrister instructed by the council, and I have one witness, and that's Councillor Peter Wilson, from whom you should have a proof of evidence.
Yeah, I do indeed. Can I just clarify, is Mr Wilson answering all parts of the inquiry into conditions, 106 obligations, or is the council going to assist, assisting with those aspects?
I will, in respect of discussions on conditions, I will assist, and there may be an officer who wants to chip in as well, if that will help the inquiry. But other than that, the evidence is to be given by Councillor Wilson.
All right, thank you for that clarification. Right, I'm out to anybody else who wishes to speak at the event today or elsewhere. I'll just take a record of your details. So if we go over to that side of the room first, then please. maybe it needs to charge up, because I think sometimes they need a little bit of time to warm up. But never mind, if you just give me your details and then we'll sort that out.
I'm also a parish councillor of Coppull Parish Council and have been nominated by Coppull Parish Council to chair the neighbourhood plan steering. Oh, I'm also the mayor of Chorley. Sorry.
Yeah, busy gentleman.
Indeed.
Okay, thank you very much. Yes, next please.
Good morning, my name's Councillor Julia Berry. I'm a Chorley Borough Councillor, like my colleague sat here representing Coppull, and I also represent Coppull as part of my division of Chorley South for Lancashire County Council. At Chorley Borough level, I am champion for strategic planning, and at Lancashire County level, I am Deputy Chair of Education Scrutiny.
Okay, thank you very much. I can move round. Anybody else who wishes to speak? A gentleman there.
Derek Keary, I'm a resident on the
Okay, can I just take your surname again, please?
Keary, K-E-A-R-Y.
Right, okay, thank you. And you're resident, right, thank you. Lady there? And you spell Moores, M-O-O-R-R-E-S, right, okay, thank you. Okay, anybody else? Yeah?
Hi, my name is Kathy, K-E-A-R-Y.
Right, okay, thank you very much. Is that everybody? Right, good, that's fine. What we intend to do is to firstly have the opening statements from the two parties, and then I'll hear from residents and interested parties this morning, so that if anyone has any availability issues later on in the week, at least you've had your say. But you can certainly continue to attend and listen, and if you want to ask further questions or make further comments later on, once you've heard some of the evidence, then you will be able to do that as well. I'll give you the opportunity. Okay, thank you very much. Right, is there an attendance list circulating? Can the council assist me with that? There will be one, right, okay, well when it does turn up, or if it's doing the rounds, everyone please sign the attendance list with their name and address, please, so I have a record of who's attended the event. Anybody from the press present? No, good. Anyone intend to film or record the event? No, good, thank you very much. Notification letters. I have copies of the council's letters of notification, firstly of the appeal and secondly confirming the date, time and location of the inquiry today, together with a list of those to whom notification was sent. So all that is in order. In terms of representations, I have 35 individual letters in response to the original planning application and 5 further letters in response to the notification of appeal. Now, I've read all those, and certainly I will take all those into account, the various issues that they raise. Can I just check that all the main parties have seen those? I think you have. Yeah, that's good. Thank
yes,
you.
ma'am, thank you.
Thank you, Mr. Cannock. So, proofs of evidence. I've received proof of evidence from both parties. For the appellant, from Mr. Saunders, Mr. Tatton and Mr. Powell. From the council, from Mr. Wilson. And I also have a proof of evidence from Mr. Terry, who is from the Lancashire Education Authority, who is dealing with the education contribution. So I have a separate proof of evidence from him. Now, I've read all those proofs, so I wouldn't expect them to be read largely verbatim, but certainly, as the advocates know, you may refer to, and I'm sure you will refer to aspects of those during our discussions. Are there any spare copies available for members of the public? I know they're all on the website, so they are available electronically for everyone to view. Do we have any paper copies? No?
I don't think so, but if anyone needs one, then just please let us know and we'll try and arrange that.
Okay, that's fine. So just let me know if anybody wants to see or view any of those. But as I said, they are on the council's dedicated webpage with all the documents to relate to this inquiry. Right, I have signed and dated statements of common ground between the appellant and the council concerning planning matters, as in land supply, and also between the appellant and the Highway Authority and Greater Manchester Ecology Unit, which deals with issues of Great Crested Newts and ecology. Those set out the areas of agreement and disagreements between the parties on all those issues. Now, just to come and have a look at the plans, please, just to clarify and check that we have the correct plans. Very helpfully from the appellant, I have a book of plans. Within there are 4 plans, I believe, which are a site location plan. I won't read out the drawing number. Illustrative master plan and parameters plan, and a proposed site access arrangement off Grange Drive. So does that appear to be correct? Is that the correct plans from all parties? Yeah. Mr. Cannock, yeah, it's in the little...
Yes, ma'am, and it's addressed in the Statement of Common Ground on planning at 2.1 on page 5. I'm probably worth mentioning at this stage, I think in a number of documents, the paragraph numbering hasn't quite worked out. So if I say 2.1 and you think it's not, it's because it will appear later. But yes, that's agreed.
Well, as long as we have the title of the document, the paragraph numbers may vary a little bit. I appreciate that. Can vary sometimes between a written copy and the electronic copies as well, which page numbering can go awry. But that's fine. Right, in terms of procedure, I've issued a draft programme for the event, and that is also on the Council's webpage. That sets out, in general terms, how we intend to proceed over the next 4 days and what we tend to cover on those days. There will inevitably be a little bit of fluidity there, depending on what sort of progress we make. So we may get ahead of ourselves, equally we might get a little bit behind. But generally speaking, we will try and stick to that timetable as much as possible. Any other advocates, have you any views or comments on that timetable? You're content with that?
It looks fine, Madam. I've got a query. The last item for this morning is 5-year housing land supply inspectors' questions. We had assumed that that was about the supply side of the equation. There's a pretty narrow dispute as to a handful of sites.
That is effectively what it is. It's about the sites in dispute, just for me to answer a few questions.
That's really helpful.
If you recall, we were going to have a round table, so it is in effect a sort of like a round table, but maybe not quite so detailed. It's just really points of clarification.
That's what we'd assume.
The appellant's evidence, and I just want to be sure of the 2 parties' positions and why you're suggesting certain sites should be reduced in terms of their delivery.
Again, if it's possible for officers to assist you in that debate, then they're to hand and they can do that.
No, I'm very happy to that. That will be helpful. That factual technical information, that's fine for officers to help.
Thank you very much.
No problem with that. Mr. Cannock, you content with that?
Absolutely, ma'am.
Yeah, lovely, thank you. So, when I've concluded my opening remarks, I will identify the main issues in this case. I will then invite the appellant and the council to each make a brief opening statement, which should be no longer than around 10-15 minutes or so. And that will help everyone understand all the main arguments. Following that, as I said earlier, it would be helpful to hear from the local residents and interested parties opposing the proposals. And those who give evidence will normally be expected to answer questions from the advocates. That is not essential. If any party doesn't want to answer questions, that's entirely fine. If you just want to give a statement, then we'll see how we go on the day. That's absolutely fine. Following that, as I was discussed, and holding a very short session around the council's 5-year land supply, in particular questions on the delivery of individual sites. So hopefully that will take most of the morning. It might be shorter than that, so we might proceed into the first witness, which is Councillor Wilson for the council in relation to housing, land supply and planning. But that is how we will continue for the rest of today, the start of the council's evidence in chief. So once that's been given, the appellant's advocate will have the opportunity to cross-examine that witness. The council's advocate may then put some questions as re-examination. So once we've heard all the evidence against the proposal, we'll then turn to the appellant to present in the same way. Evidence in chief, cross-examination, and then re-examination. And I may ask questions at any stage. And I will also indicate that local residents and interested parties those who wish to speak, may wish to ask questions of parties through me, and I will allow that at an appropriate time. Once we've completed all the evidence, we will then have a round-table discussion on the requirement for an education contribution. That's when Mr Terry from Lancashire County Council will be joining us. And following that, there will be a further round-table discussion to discuss the conditions and the planning obligation. Now, when discussing conditions and the obligation, that is normal practice. It does not mean that I've made my mind up. It's just purely that I have all the information I need should the decision be allowed. I have a list of draft conditions. I'm not quite sure whether that's the final list or whether there is still some discussion going on.
And I've been handed a list this morning, which I understand is entirely agreed. I don't know if that's the same list that you have, but should we give you a copy of the list that I've been given this morning?
I think that would be helpful. The list I've got, I think I received on the 27th, and there were a few elements not quite agreed at that time. It was nearly there, but not quite.
Things have moved on, and I think we're at a point of now complete agreement on the drafting. So I'll hand that up and around.
Okay, thank you very much. Okay, thank you, Mr Ponson. I've also seen a draft Section 106 agreement, and I'm sure all parties know that needs to be signed and dated, preferably before the end of the inquiry. Can you update where that's up to, Mr Cannock? Do we have further progress?
Yes, Ma'am. There's been some late changes to it. I'm not sure how much detail you want me to go into.
Go into a lot of detail.
Well, what I'm going to ask my solicitor to do, because essentially you'll know through the education contribution, there's been this latest position of Lancashire County Council where they've suggested that there may be an interim position between full and zero, which is 92,000. And so I've asked for the Section 106 to be updated to reflect that, because of course that may be part of your decision. I think there's also a request has been made which needs to be taken out. Those matters aside, I'm instructed that the document is essentially agreed as between us and Chorley. I think in the game of tennis, it may technically be with Chorley at the moment to comment, but it's very well advanced. I don't anticipate it being in dispute, and I'm going to ask Shoesmiths to circulate the version that we have tonight. And I don't know, can we send that to you electronically, or would you prefer a hard copy?
For the event, I prefer a hard copy, but I'll need an electronic one anyway for our records.
Well, we'll do both, and Mum, if you could provide your details at a break, then we'll undertake.
Well, you just send it through to the case officer,
right?
In Pins, and then they direct it back to me.
So yes, Mum. So that's the position on the Section 106, and with an intention, when we come to discuss it, it won't necessarily be signed and dated, but the idea is that because once you do that, it becomes difficult to change it. But we'll discuss that in the normal way, and then we'll ask for some time just to have it signed and dated.
That's how we can agree that later. Yeah, thank you. Right, so after our discussion on 106 and conditions, we will then hear closing submissions from the council and the appellant. And I'm sure both parties know that would be helpful for me if that's in writing. Save me doing lots and lots of note-taking. Following that, there will be an opportunity for either party to make an application for costs. So clearly, I'm not inviting costs, but again, that needs to be done here at the event and also in writing if possible, please. The only thing remaining after that is to discuss the site visit. As I previously indicated at our case management conference in August, I think it was, currently I envisage undertaking an unaccompanied site visit, as there are public rights of way that cross the site, but I'm quite open to have further discussion on that later on at the end of the event. So any comments from anybody on the running order? We're happy to proceed. Yes, sir.
Could I just, for your convenience, make you aware that at midday today I will have to be in a meeting with St Catherine's Hospice AGM, so if you could accommodate that within the running order, I'd appreciate it. Right,
in that case we'll have you first on the slot then for the interested parties, then you can go whenever you need to.
As long as I'm not called a queue jumper, thank you.
Okay, all right then, thank
Mark,
you.
can I raise two issues on documents, and apologies if I've
All right.
missed it. The first issue is just absolute clarity. There was a rebuttal submitted by Mr. Saunders, which has subsequently been withdrawn. I just wanted absolute clarity on that. Thank you. And then the second point is, Mark, you should have received, I think it was circulated early last week, some additional documents which pertain to the roundtable session on education. I've got for you and Mr. Ponter hard copies of the relevant documents if you'd like them.
Well, that would be helpful. Yeah, I have them electronically, but yeah, I'm quite happy to have a hard copy. Yeah, I was going to come on to documents actually, but never mind. It's fine. No, it's not a problem. Yeah, I mean, it's not new evidence. I do have this electronically anyway, but yeah, thank you. Yeah, that's helpful. Thank you.
I just check that obviously this is of interest to me, but it's probably of more interest to the county council. Can I just check that the county council have had this? Thank you very much.
Yes, Mr. Powell has been liaising with, I think it's Mr. Terry at the council.
Right. Okay, thank you. Yeah, anything else on documents? I think we're
No, Ma'am, thank you.
we're okay. No new evidence, hopefully. Good. Right. In terms of time estimates, we have 4 days for the inquiry, which I'm sure will be perfectly adequate. I'll break for lunch around 1 o'clock each day, about an hour with short breaks morning and afternoon at appropriate times in the proceedings. I aim to finish no later than 5 o'clock, maybe earlier on some days, just depending on how we're getting on. So, main issues and other matters. The original planning application was refused for 4 reasons. Of those, reasons for refusal 2, 3 and 4, which relate to ecology, highways, master planning and connectivity, are no longer in dispute between the parties and are not being progressed by the council. So therefore, in light of that, the main issues relate to reason for refusal 1, which I have summarised in relation to 4 points. Firstly, what is the current housing requirement for Chorley Borough in regard to the provisions of the development plan and national policy? Secondly, whether the council can demonstrate a 5-year supply of deliverable housing land against the housing requirements. Whether or not the most important policies of the development plan for returning the appeal are out of date, having regard to the 5-year housing land supply position and relevant national policy. And lastly, whether this or any other material consideration would justify the development of safeguarded land at this time. Now, I am aware that there are various other matters raised by local residents in particular, including highways issues, local infrastructure, such as doctors, dentist schools, and I will be examining those throughout the inquiry. They may not be in dispute between the council and the appellant anymore, but they are matters that I am interested in, so I'll be very happy to have discussion by residents on that, and I think Mr. Saunders has addressed some of this in his proof anyway, as a general roundup for other matters. So, any comments on the issues? Mr. Ponter, Mr. Cannock? No? Excellent, thank you. So, that concludes my opening remarks for this morning. I don't think there were any queries about what we're going to do and how we proceed. So in that case, we will start off then with the appellant's advocate making a short opening statement. That's over to Mr. Cannock. We have the own paper, thank you. Right, so when you're ready, Mr. Cannock, thank you.
Thank you, Ma'am. I can't explain the yellow highlighted band at the top of the page. It's not part of some new branding exercise. Ma'am, these then are the opening submissions on behalf of the appellant. You've asked for a short thumbnail sketch. Obviously, the detail is set out in our submitted evidence. By way of introduction, this appeal concerns an outline application for up to 123 dwellings, of which 30% or 37 dwellings will be affordable homes. Structural planting and landscaping, public open space and vehicular access points from Grange Drive. All matters are reserved save for access. A A full description of the developments is contained in the design and access statement and the statement of common ground. The application does not comprise EIA development, but by which I mean it does not require an environmental impact assessment. It seeks consents for two matters, the principle of development and the detail of the points of access. The application was refused planning permission in a decision notice dated the 13th of April 2021 for 4 reasons, which were briefly, first, development of safeguarded land contrary to policy BNE 3.6 of the Chorley Local Plan. Secondly, insufficient information on great crested newts contrary to policy BNE 9. Thirdly, lack of a comprehensive approach to the redevelopment of site BNE 3.6 contrary to policy BNE 3.6 and ST1 of the Chorley Local Plan and policy 17 of the Joint Core Strategy. And fourthly, insufficient information on highway safety contrary to policy BNE 1D of the Chorley Local Plan. Ma'am, the appellants never considered reasons for refusal 2 to 4 to be properly arguable. Such issues could and should have been agreed earlier had the local authority engaged meaningfully in the application process prior to refusal. It is, however, now agreed that all matters in reasons for refusal 2, 3 and 4 have been addressed through the submission of additional information. Further topic-specific statements of common ground, as you've identified, have been agreed with the local authority in respect of ecology and Lancashire County Council as local highway authority in respect of highways. There are no outstanding issues. Accordingly, there is a single reason for refusal which concerns the site's designation as safeguarded land. And Ma'am, in those circumstances, I set out the main issues. There's a slightly different formulation. I don't think anything particularly turns on that. I suppose the one point that I might just highlight is that on our case, policies are out of date because they're out of date and also as a result of a lack of a 5-year supply. So we have 2 aspects to our case there. And so, Ma'am, ultimately, point 5, the issue is whether on balance the proposal comprises sustainable development because the adverse impacts of the proposal significantly and demonstrably outweigh the benefits of the proposal. That's our case, Ma'am. We rely on the application of the tilted balance. But in any event, whether on balance material considerations outweigh the conflict with the development plan. And the main issues, of course, fall to be determined in accordance with the development plan unless material considerations indicate otherwise. That is the statutory test in section 38(6) of the Planning and Compulsory Purchase Act 2004. In terms of common ground, Ma'am, there's no issue on the detail of the proposed accesses to the site. The sole contested issue concerns the principle of development, and there is a significant measure of common ground on the principle of development. The site was designated as safeguarded land going back to the Chorley Local Plan of 1997, applying PPG2 on green belts. The designation of the site as safeguarded land meant that the local authority considered the site to be genuinely capable of development when needed and an efficient use of land well integrated with existing development and well related to public transport and other existing unplanned infrastructure, so promoting sustainable development. There is therefore no issue with the principle of development of the site per se. The site is accepted to be a sustainable location for new housing development. There are no technical constraints to development or objection from statutory consultees. It's agreed that the consent would deliver comprehensive development of the site designated as BNE 3.6. Rather, the issues concern when this site should be developed for housing. The site is currently proposed for allocation by the LPA in the emerging Chorley Local Plan, which is proposed to be adopted by November-December 2023. Such a timing issue is therefore vanishingly small and of no materiality. The LPA is nonetheless concerned that the grant of the consent now would prejudice the emerging Chorley Local Plan. It's conceded by the authority that there's no prematurity argument, and on examination we submit there is no arguable prejudice to the scale, location or phasing of housing development in the emerging plan, which has a period of 2021 to 2036. Turning to the development plan, I define the statutory development plan so far as relevant, which comprises the Joint Core Strategy adopted July 2012 and the Chorley Local Plan adopted the 21st of July 2015. And Ma'am, you will understand that that is a part 1 with the Chorley Local Plan being the Part 2 plan. Article 35 of the Development Management Procedure Order 2015 requires the reasons to refusal to be full. Conflict is alleged solely with policy BNE 3.6. It's common ground that the proposal conflicts with that policy. It is therefore necessary to understand whether the development plan is up to date and consistent with the framework. Turning then to the background of the core strategy and local plan. The regional spatial strategy for the North West was based on the PPS3 housing methodology. It was based on the 2003 household projections from 1998 to 2003, which resulted in 416,000 households across the region. The 2003 household projections were then manually redistributed across the North West and Central Lancs in accordance with the spatial strategy. The RSS housing requirement was for Chorley 417 dwellings per annum, Preston 507 and South Ribble 417. The joint core strategy was required to be in general conformity with the RS. The examination in public inspector required the joint core strategy to adopt, in the terms of the report, the RS housing requirement without further analysis. That was main modification 1. The minimum housing requirement in policy 4 is therefore based solely on the regional spatial strategy for the North West. Policy 4 is based on the RS PPS3 methodology, which resolved a housing requirement at the regional level before it was manually redistributed. Policy 4 is therefore based on the 2003 household projections, which are based on evidence between 1998 and 2003. It follows that Policy 4 cannot be used as a proxy for an objective assessment of housing need, applying well-known case law, with which I'm sure you're familiar, in Hunston and Gallagher, and Gallagher is certainly part of the core document. The housing requirement for Chorley in Policy 4 is constrained, significantly out of date and inconsistent with the framework. The Chorley Local Plan planned to meet the housing requirement of the Joint Core Strategy without further analysis. The local plan is based on the out-of-date RS Joint Core Strategy housing requirement, and in that context, the purpose of the settlement boundary of Coppull is twofold. Firstly, to provide an area, the urban area, inside of which housing is acceptable in order to meet the identified need for housing in the RS Core Strategy. And secondly, to provide an area outside of which development will be restricted because it's not needed to meet the identified need for housing in the RS Core Strategy. This is safeguarded land and the Greenbelt. Safeguarded land is protected to meet longer-term development needs. Policy BNE 3.6 is therefore essentially a timing provision. However, as previous inspectors have concluded, as the settlement boundaries and the safeguarded land boundaries are based on the housing requirements of the revoked regional strategy and the joint core strategy, they are also out of date and inconsistent with the framework, regardless of the position on 5-year supply. The appellant therefore submits that the tilted balance is engaged because policy BNE 3.6 is out of date. Further, whilst there is conflict with policy BNE 3.6, it is not a conflict to which significant weight can attach, given that the policy is out of date and inconsistent with the framework, as interpreted by Hunston and Gallagher, and I also refer to the Supreme Court decision in the Richborough Estates case. Turning then to housing land supply, further or alternatively, the appellant submits the authority do not have a 5-year housing land supply, and there are 3 contested issues. Firstly, whether policy 4 or local housing need derived using the standard method should form the basis of the 5-year supply calculation. And secondly, whether the annual housing requirement should be significantly reduced to take account of oversupply in the planned period. Ma'am, just perhaps a pedantic note at this point, but we don't accept that the term oversupply is the correct use of the term, but it's been used as a convenient shorthand. And I'm sure the inquiry will do so, but I did want to put a marker there. And then the third point, ma'am, is the deliverable supply. And as Mr. Ponter has prefaced, neither party considers this difference to be material and or to require determination. The 5-year supply can appropriately be reported as a range, but of course, ma'am, you have your own questions. The issue of oversupply does not apply to the application of the local housing need derived using the standard method because it's rebased annually. On that basis, it's common ground that the authority must win on both issues 1 and 2 in order to demonstrate anything over a 3.5-year supply. The appellant's case is that the 5-year supply should be calculated using the local housing need figure of 537 dwellings per annum. Whilst it's acknowledged that there has been a review of the housing requirement for the purposes of framework paragraph 74 and footnote 38, the review concluded in October 2017. It significantly predated the publication of local housing need and the standard method in the NPPF. The appellant therefore submits that there have been a number of material and significant changes in circumstances since the completion of the review, which justify the application of local housing need as the basis of the 5-year supply. This is the approach of Preston City Council and South Ribble Borough Council, and has been upheld recently in the second Chainhouse Lane decision letter, which is the latest decision on this issue, and the appellant submits that there should be consistency of approach across the HMA. Ma'am, just as a point of housekeeping, it's right to say that that decision letter, as I think you know, is the subject of an extant challenge, but of course it will be considered to be regular unless and until it is overturned. And I think the same applies to the Cardwell Farm decision. Further, or alternatively, the appellant submits that there's no robust justification for a significant reduction in the Policy 4 annual housing requirement from 417 dwellings per annum to 104 dwellings per annum, or 109 dwellings per annum with a 5% buffer, which is the authority's approach. The authority's approach is, amongst other matters, I didn't want to be comprehensive at this stage, it is inconsistent with the clear wording of Policy 4. It's inconsistent with the framework. There's no support for it in either policy or guidance. It seeks to treat minimum housing requirements essentially as targets, which is the antithesis of the framework imperative to boost significantly the supply of housing. On that basis, the appellant submits the 5-year supply is between 3.1 and 3.4 years, applying Policy 4 without the oversupply reduction, and secondly, between 2.4 and 2.6 years, applying local housing need consistent with the other authorities in the HMA. I'm trust that you're sufficiently clear that it's that second point which is our primary case. The first point is our secondary case if you don't support the conclusion on the application of local housing need. Even if Policy 4 is applied with a significant discount for the purposes of the 5-year supply calculation, the framework 2018 or 2021 and local housing need remains a material consideration of significant weight. You can't airbrush it out of the determination. This plan period ends in March 2026. A new plan is set to be adopted by December 2023, with a plan period of 2021 to 2036. A new plan must be adopted soon in order to have continuity in the plan-led system. The fact, and it's agreed, is that this authority has only a 2.4 or 2.6 year supply, applying the local housing need, and this is a material consideration of significant weight and raises significant concerns amongst other things. Firstly, the delivery of affordable housing in the plan period. Secondly, the delivery of housing across the HMA and what Preston and SRBC together with Chorley are doing across the HMA. Thirdly, meeting the housing delivery test, which is an ongoing forward-looking policy requirement. And fourthly, ensuring an adequate forward supply of housing at the start of the next plan period, whether that's 2021, which is the current plan period, 2023, which is the forecasted point of adoption, or 2026, which is the current end of this plan period.
I'll just interrupt you there, just really for the benefit of residents. When Mr. Kant's referring to the HMA, that means the housing market area. That basically means the whole area for Preston, South Ribble and Chorley, the area where the housing market is interconnected in terms of where people live, where people work and how they travel. So when the HMA refers to the housing markets for Preston, South Ribble and Chorley. Thank you. Sorry.
No, thank you, Mama. I tried to explain the acronyms as I'd gone along, but I missed that one, and it is important. Thank you very much. So turning then to a balanced consideration of sustainable development. Of course, the framework requires decision-making to be approached in a positive way. Decision makers at all levels should seek to consent proposals for sustainable development where possible, consistent with the imperative to boost significantly the supply of new homes. The framework expresses a presumption in favour of sustainable development, and sustainable development comprises a social role, an economic role, and an environmental role. The roles are, of course, mutually dependent and need to be pursued in mutually supportive ways. Turning then to the social role and the need for market housing. In the absence of a 5-year supply, it's submitted that significant weight should attach to the need for more market housing. But even if there is a 5-year supply, the NPPF 2018 onwards sets a minimum housing requirement for Chorley of 537 dwellings per annum, which is a significant increase on the out-of-date 417 dwellings per annum in the regional spatial strategy and the joint core strategy. On either basis, significant weight must attach to the need for housing when the LPA has a forward supply of just 1377 to 1504 units. Turning to affordability and the need for affordable housing, the proposal will deliver up to 37 new affordable homes. The SHMAR, which is the Strategic Housing Market Assessment 2009, identified an estimated annual shortfall of 723 annual homes per annum in Chorley between 2009 and 2014. That was the last SHMAR which has been tested at an examination in public and formed the basis of Core Strategy Policy 7. The Central Lancs Core Strategy of 2020 demonstrates an annual shortfall of 132 affordable homes for rent. Applying the development plan, this would require 186 affordable homes in total because there's a 70-30 requirement for a split. The delivery of market homes is the only mechanism by which a significant amount of affordable homes will be delivered, and 620 dwellings per annum would be required to deliver that identified need for affordable homes on the basis that Policy 7 requires a 30% of market homes to be affordable. A planned requirement of 104 dwellings per annum is woefully inadequate. Further, at approximately 6 times lower quartile earnings, lower quartile house prices in Chorley are now practically unaffordable for a large section of society. And this can only be meaningfully addressed by providing more housing in Chorley, something which the Joint Core Strategy housing requirement and the restrictions of safeguarded land have been constraining. It follows that the development derives very significant support from the need to address affordability and the need for more affordable housing, to which very significant weight should attach. In terms of sustainable location, Coppull is a sustainable settlement. It's agreed that the proposal complies with Policy 1 of the Joint Core Strategy. Further, given the site's designation as safeguarded land, it's considered to be acceptable to accommodate future development needs. The appellant therefore submits that firstly, Coppull is a sustainable settlement for future growth in the planned period and beyond, and secondly, the appeal site is an accessible site adjacent to this sustainable settlement. There's no highway impact, which is arguably severe. The proposal complies with the core strategy and the framework. The proposal therefore derives significant support from the social role of sustainable development as a whole. In terms of the economic role, the application has demonstrated the socio-economic benefits of the proposal. The economic benefits can be summarised very briefly as £15.4 million of construction spend, supporting 35 full-time equivalent jobs construction for a period of 3 years, and direct, indirect and catalytic economic benefits as a result of such investment in employment, comprising £17 million gross value added, supported an additional 62 indirect jobs. These economic benefits are an important material consideration in support of the proposal. They may be benefits of any housing development, but they are nonetheless benefits of this housing development to be weighed in the application of the statutory test. They should be afforded significant weight individually and cumulatively. And further, of course, such economic benefits will be lost if the LPA continues to apply an annual housing requirement of 104 dwellings per annum. It follows that the proposal derives significant support from the social and economic roles of sustainable development. In terms of the environmental role, the reasons for refusal do not raise any issue regarding heritage, design, residential amenity, ecology, flooding, landscape and visual impact or pollution. It's accepted that there will be an adverse landscape and visual impact, but it's no more than the inevitable impact of any greenfield development. There's no alleged impact with policy and no suggestion that it's in any way unacceptable. On the contrary, this is a site to which the authority have directed development to meet needs. Accordingly, the sole impact derives from policy conflict with policy BNE 3.6, as the site is currently safeguarded land. For the reasons given above, the safeguarded land policy must be given limited weight. Further, there is no tangible land use planning harm which flows from the breach of policy. BNE 3 is a timing provision, and there is no adverse impact as a result of a consent being granted on a draft allocation in a plan set to be adopted in 2 years' time. Further, there's no prematurity point and no arguable prejudice to the plan-making process, and the appellant therefore submits that on the application of the tilted balance, there are no adverse impacts which significantly and demonstrably outweigh the benefits. On the contrary, the benefits significantly and demonstrably outweigh any conflict with policy BNE 3.6. And or secondly, material considerations significantly outweigh the conflict with the development plan. In terms of the education contribution, there is a dispute with the authority over whether the requested secondary school contribution complies with Regulation 123 of the Community Infrastructure Levy Regulations and the NPPF. Regardless of the resolution of this issue to be addressed at the roundtable session, it doesn't impact respectfully on the decision to grant consent. A Section 106 is provided. It's subject to a trigger clause requiring UMARM to consider whether such a contribution is necessary. If, contrary to the evidence of Mr. Powell, it is necessary, it will be provided by the Section 106 planning obligation. And in conclusion, Ma'am, it is therefore our case that planning permission should be granted subject to conditions of the Section 106 planning obligation.
All right, thank you, Mr. Connick. I'll now then turn to Mr. Ponser for the council. Your opening statement, please.
Stick to text. There's one or two additional comments that I'll interpose in response to what we've just heard. I'm going to stick to my 5-minute estimate there. Rest assured.
That's fine. Well, if there's any additional comments, I can just make a brief note. That's
Very
fine.
much indeed. I start by noting the obvious, which is that the starting point for this appeal, as for all such appeals, is the development plan, which, as you've heard, comprises the core strategy and the Chorley local plan. And common to, that's a cut and paste there, I'm afraid. In respect of this appeal, the designation of the appeal site as safeguarded land within the development plan is central. Policy BNE 3 of the local plan identifies 11 areas of safeguarded land within Chorley. And the appeal site comprises one of those areas, and that's referred to as BNE 3.6 within the Chorley local plan. And we note that the requirements of that policy could not be clearer. It says that development other than that permissible in the countryside, whether green belt or area of other open countryside, won't be permitted on safeguarded land. And Madam, some context to that. The purpose behind the protection of safeguarded land is, we say, well understood. And it's explained in the supporting text to BNE 3. In order that the greenbelt boundaries should be long-lasting, land between some major settlements in the greenbelt is safeguarded for future development needs beyond the planned period. Now, recognition of the need to ensure that greenbelt boundaries are long-lasting has been a cornerstone of national greenbelt policy for decades, as has the role of safeguarded land in achieving that end. It remains the case in the most recent expression of government policy, and that's the 2021 revision of the framework, that the essential characteristics of greenbelts are their openness and their permanence. Madam, can I just note there that central national policy provision in respect of greenbelts isn't referred to in the appellant's opening submission. We say it is a fundamental component of the relevant national policy context in this case. And the stress under the permanence of greenbelt boundaries is mine in the quote. So, national policy continues to recognise the role played by safeguarded land in ensuring the permanence of greenbelt boundaries and makes it clear that strict control should be exercised over development on such land. And I quote from paragraph 143 of the 2021 revision of the framework, which restates the requirement that planning permission for the permanent development of safeguarded land should only be granted following an update to a plan which proposes the development. And can I just add there, Madam, that not only is there a breach of policy BNE 3, in fact, this is the point I make over the page of paragraph 8, not only is there a breach of policy BNE 3 in this case, which is undisputed, there's also an infringement of up-to-date national policy, which is the provision of paragraph 143 of the framework that I've quoted. Again, recognition needs to be given to that breach of national policy, and I don't think it was recorded in the Learned Friends' opening statement. So where there is a breach of the development plan and indeed national policy, we say there should be some compelling reasons in order to justify an outcome that involves the grant of consent, and we say there aren't in this case. One other point to note before I deal with the issue of housing land supply is this. I think Mr. Cannock's theme, or at least one of his themes, was, well, this is all just a question of timing. Because if we wait for the next local plan to come along, this site will be allocated for housing. There is absolutely no guarantee of that. It is agreed between the parties that the emerging local plan is at an early stage. It has an issues and options paper published, but hasn't got to any further stage than that, and therefore attracts limited weight. With respect, the suggestion that this site is identified in an issues and options paper for an emerging local plan, we say can't possibly justify the release of safeguarded land at this stage. Housing land supply. Ultimately, the appellant's case turns on the contention that the council faces an inadequate supply of land for housing for the next 5 years. That debate has little to do with the extent of supply. I think the dispute in respect to the components of supply is properly described as a narrow one. We are at a figure of 1,504 dwellings for the 5-year supply picture, and the appellant's assessment is 1,377. And that's recorded in the Housing Land Supply Statement of Common Ground, Madam. Instead, the central dispute concerns the level of requirement to be used in the calculation. 2 points of contention. First, the application of the development plan requirement for Chorley contained in policy 4 of the core strategy, and that's our approach, versus the use of a local housing need figure derived by application of the standard method, and that's the appellant's approach. Secondly, if the policy 4 figure is to be used, the deduction of previous years' oversupply from the requirement, our approach, versus an assessment that makes no deduction for oversupply in previous years, that's the appellant's approach. Now, in respect of the first of those issues, there are 2 recent appeal decisions, as you'll have seen, and I give the core document reference numbers, both determined earlier this year in respect of schemes in the 2 other central Lancashire council areas, and that's Preston and South River. Those 2 inspectors reached different conclusions. In respect to the Preston decision, that's Cardwell Farm, the inspector applied the development plan requirement in core strategy policy 4. In respect of the South Ribble decision, Chainhouse Lane, the inspector applied the standard method figure. I do note there, I think Mr. Cannock made a passing oral reference to Cardwell Farm in his opening statement. I couldn't record in his written note any reference to Cardwell Farm. There are 2 competing decisions, each of which carry equal weight. And it's a question of judgment, we say, as to which approach is to be preferred. The Council demonstrates in its evidence to this inquiry why that judgment should be exercised in favour of using the Policy 4 housing requirement in light of the particular circumstances in Chorley. And those circumstances are addressed in Councillor Wilson's evidence, and we'll be examining them over the next few days. Accordingly, we say that the first of the two main issues in respect of housing land supply falls in favour of the Council. Similarly, in respect of the second main issue on housing land supply, in the absence of any national policy or guidance in respect of the treatment of previous years' oversupply when setting the 5-year requirement, it is a question of judgment as to the approach to be taken, to be determined on a case-by-case basis. Again, as we demonstrate in our evidence, there are clear reasons why oversupply should be deducted from the requirement in Chorley. Accordingly, the second of the two main issues in respect of housing land supply falls in our favour. The result of applying the Policy 4 requirement to the 5-year assessment and taking account of previous years' oversupply means that the Council enjoys a substantial supply of land for housing, whether that's our figure, 13.8 years, or the appellant's figure, 12.6, the difference being immaterial to the outcome of the appeal. Accordingly, the position is one of plentiful supply as opposed to shortfall. There can be no suggestion that the tilted balance is engaged on the basis of inadequate provision of housing land. Given the plentiful supply of land for housing, there is no other basis on which to conclude that the most important policies of the development plan for the determination of this appeal are out of date. In particular, local plan policy BNE3 in respect of safeguarded land is entirely consistent with the framework, and I don't understand that point to be disputed. In terms of its drafting and approach, there is no inconsistency between what BNE3 says and what up-to-date national policy says. And secondly, Policy 4 of the core strategy, which contains our housing requirement, has been reviewed following the completion of a strategic housing market assessment in 2017 and found to be consistent with that assessment. So again, I just add there, Madam, whilst you've heard quite a lot in the appellant's opening about the source of the figures in Policy 4, and their source was in the now defunct regional strategy, all very interesting, but it ignores the point that in 2017, that policy was reviewed and found to be up to date. And that, as we know, is within the last 5 years, and we'll come to the significance of that in due course. So, the result is that this appeal falls to be determined in accordance with the conventional, not tilted balance, flat balance as it's sometimes called. We say that there are no material considerations that justify the breach of the development plan and indeed national policies, and will invite you to dismiss the appeal. Thank you very much indeed.
Okay, thank you, Mr. Ponter. Can I ask the Council, is it possible to put the opening statements on the core documents on the website at some point?
If I could have them emailed to me, then I can arrange for that.
Well, so sometime by the end of today, that'd be fine. Yeah, okay, lovely, thank you. Right, so what we intend to do now is to invite interested parties who wish to speak. And as I said before, we'll start off with Councillor Holgate, as previously requested. So, Councillor Holgate, are you content sitting over there? Are you okay there? Do we have a microphone that's working for you?
Yes, this one works, but
Oh, okay. Oh, that's fine. Right. Thank you.
you know I'm in full view of it. Right.
Right, yes. When you're ready then, Councillor Holgate, thank you.
Thank you, Madam Chair. As said, well, first of all, this will be a lesson in brevity to our previous speakers. My name is Steve Holgate. I'm a parish councillor, I'm a district councillor, I'm the Mayor of Chorley. But perhaps more importantly in this forum, I'm chair of Coppull's Parish Council's Neighbourhood Plan Committee. A very important committee to the community in terms of trying to get a grip on and some better influence on the way in which our village shapes and develops. I hope to talk briefly on the issue of what planning is and what planning means to local people. The dry bone stuff will lead to people with legal minds, and other issues will be picked up by my ward colleagues, Councillor Julia Berry, Alex Hilton, and the good residents that have turned up today to speak up for the village. The council have given a number of reasons to decline the application. But I want to talk really about the democratic process. Coppull has taken a lot of time and trouble to engage with local people to create a committee called the Neighbourhood Plan Steering Group. To that end, we believe that it is important for a successful, vibrant village to have a big input from local people. Safeguarded land is made available under a local plan in case allocating land does not become available during the local plan. That is the purpose of allocating safeguarded land, in my understanding. And that should be during the plan period. And even then, may not be found to be appropriate for many other reasons. The purpose for safeguarding land is one major omission in the appellant's presentation was the aspiration of local people to shape their local community. The issue to do with the dry bones of planning legislation is important and will be brought out in the full. But I think it's important that you as the person who will allocate the decision at the end of this process takes account of people's aspirations locally and their willingness and wish to take part in the process. In bringing forward this application at an early stage, denies local people the opportunity to be involved in that process. And given that the government, not this government, but successive governments, have always tried to encourage people to get involved in developing a local neighbourhood plan, I think it is wrong that this should be bounced through at this stage, which is how I feel the process has gone so far with the appellant making this appeal. In summary, this site is safeguarded land, is on safeguarded land, and it is in safeguarded land the whole period of the local plan. The democratic engagement of the community in shaping the community and its built environment, and how it looks and develops, being encouraged by successive governments, will be undermined, if not blown out of the water, if this land, safeguarded under the local plan, is allowed to be developed at an earlier stage than originally planned. If this development is allowed to progress at this stage, it stops becoming a planning process and becomes a free-for-all, perhaps better described as a planning chaos rather than a planning, because planning is in fact about trying to create a mode and a period of time over which plans come to fruition. Bringing this in at this early stage undermines that. And I think the residents of Coppull wish me to make that point to you.
Thank you very much, Councillor Holgate. Mr. Canutt, do you have any questions or points of clarification?
Just a few more, if I may. Councillor, of course, the neighbourhood plan process has been in force in national policy since at least 2012, hasn't it?
It does indeed.
So the residents of Coppull have had at least the best part of a decade in which to put together a neighbourhood plan, haven't they?
They have indeed.
Now, I just want to understand what formal steps, if any, towards the process of adoption of a neighbourhood plan have been reached. Do we even have a designated area as such yet?
We have a designated area which was agreed by full council of Chorley Borough, which is the requirement, two full council meetings ago, yes. So we do have that process.
Right.
It's fair to say that at any given time, I mean, there are thousands and thousands of parishes that have started the process and completed it. There are others that are in the process, of which Coppull is one, and there are some that haven't even occurred to them because they're not aware of it or they haven't been made aware of it. So I think to infer that Coppull are behind the curve for their own reason, for the wrong reasons, and have been lax in some way is churlish, to be honest with you.
Right, but there's no plan or any version or draft of a plan that I can look at as such as yet, is there?
There is not.
And I just want to understand this. I don't want to take you to the framework, Ma'am. For your notice, paragraph 66 of the NPPF. But you understand that it will be for the next local plan to set out strategic policies which will set out the housing requirements for designated neighbourhood areas, isn't it?
It is, and Coppull Parish Council and the Neighbourhood Plan Steering Group have been very mature in recognising that a neighbourhood plan is not there to create a situation where a village is frozen in time in terms of built environment. There is a recognition that the whole process is a moving feast. However, they want to be a part of the decision making within that moving feast and not sidelined as a consequence of 2 or 3 or even more local areas being brought forward for planning permission prior to their opportunity to have that, be a part of that process. It's called democracy.
Okay, but what the process will be is surely we'll go through a local plan process, at the end of which you will have your housing requirement for your designated neighbourhood area. And it's at that point that you will then go through your neighbourhood plan process. That's what needs to happen, isn't it?
No, that is not what happens. The two will work in tandem, and we'll try and ensure that they dovetail. If to do them separately will be a missed opportunity. Like I say, there's been some very mature conversations locally by local residents and parish councillors about how this process goes forward.
Okay.
And the aspiration is that it goes forward in tandem with the local plan.
Even if it was to go through in tandem, and respectfully, I don't understand how that can happen, because you can't have consultation on a draft until you know what the strategic housing requirement is to which you need to plan. But I'll take your point that they dovetail. You still cannot adopt your neighbourhood development plan until you have at least some degree of certainty as to what the strategic policies are setting down as a housing requirement for your neighbourhood designated area, can you?
Well, it's not relevant because the local plan, the neighbourhood plan cannot be adopted until a referendum has taken place in Coppull and it has been agreed by the people of Coppull.
That's a slightly different point. Okay. You're not here, I don't think, Councillor, to raise any prematurity argument in respect of the neighbourhood plan, are you?
I am indeed.
You are?
Of course, yes, absolutely.
Right.
Well, perhaps prematurity is not the right word, but certainly the plan period that is allocated at the moment should come to its fruition, and the new plan period started before land of this nature, safeguarded land, is allocated. Safeguarded land is allocated, if my recollection was when I was chair of the planning committee at Chorley, was there in order to ensure if allocated land had not been come forward as expected, there were a second string that would enable us to complete and provide the land required under the neighbourhood plan, despite the fact that perhaps for reasons of finance or access, a piece of land that is allocated under the local plan does not come forward, that is when you come to the point where you can look into the fact that it's safeguarded land. It's not something that should just be bounced in earlier because of the aspirations of a developer. Thank you.
Okay, I'm not sure I understand that answer. My question was about prematurity of the neighbourhood plan. You're aware, are you, that there is national policy on prematurity in the National Planning Policy Framework? Are you aware
Of the neighbourhood plan?
Yes. You're here to talk about the neighbourhood plan. I'm
Yes.
asking about the neighbourhood plan. Are you raising an issue of prematurity in respect of the neighbourhood plan?
No, I'm not. I'm saying that the neighbourhood plan is being undermined by the fact that the opportunity to go through that process with the community is being denied if this planning application goes forward.
I understand that. You also have a relationship with the parish council. Sorry, my note says chair of the parish council. I'm not sure that's quite what you said. What's your role in the parish council?
I am the chair of the steering group set up to develop the neighbourhood plan.
Right. It's right to say, though, that there have been two processes of call for sites as part of the emerging local plan, haven't there?
There have.
And as part of that, the parish councils were expressly consulted, weren't they?
They were.
And Coppull Parish Council had no objection to the allocation of the appeal site for housing in the next plan period, did it?
Not in the next plan period, no. In this plan period, it's a different matter.
Well, the next plan period is 2021 to 2036, isn't it?
Which is why I said in my statement that even allocated land as safeguarded doesn't necessarily guarantee coming forward, because there are a number of other reasons why that allocated site is not appropriate.
Yeah, but just come back to the point. Expressly being consulted, the parish council had no objection to the allocation of this site, did it?
In this plan period, yes. Which is, the application is for this plan period, is it not?
I think we've done this. No objection to the allocation of this site in the next plan period, 2021 to 2036.
As a barrister, you should know better than ask me to be non-specific when I can be specific.
I think I've
I
heard
will
enough on this
remain
point,
being
Mr. Cannock.
specific.
Sorry, Councillor. I think I've heard enough on this point.
It's
I
an answer.
understand the councillor's view quite clearly, so I think that's adequate for my purposes. Thank you, Mr. Cannock.
Thank you,
Okay.
Chair.
Thank you, Councillor Holgate.
Yeah, okay, thank you. Very flexible around here.
Right, thank you, Councillor Berry. When you're ready.
Thank you. I'm here as one of a team of local councillors today. As I'm a councillor for Coppull, as the district council, and also a Lancashire County councillor for the area. I want to just briefly look back at the planning application which came to committee, which was unanimously refused in April. In summary, I recommended that it was premature, insensitive and flawed. And for these reasons, really, Coppull residents take their responsibilities as custodians of their village very seriously, and are working with the parish council and Chorleybury Council to shape and support the neighbourhood plan and the emerging local plan. And we recognise as part of that process that planning development plays a part, but it's got to be when locally we're confident that the infrastructure is visible and it's there to support the village. Just bear with me a minute. I do apologise, I've just juggled the papers. Like I say, it's just really important that we recognise at every level of local government that we have to have a plan, and having premature speculative applications coming forward before that time, just is very destabilising and very, takes away local trust. And that's what I hope over this period of time that we can reinforce this reason why local representatives aren't in favour of this application. I'd also like to put on record, I did state at the last, that when it came to committee, that there was limited and insensitive consultation by the developers and their agents. It came to a time when residents could not meet due to COVID restrictions to even meet face to face with their own family, their neighbours or their local political representations. And have the developers or agents been back since then? No. I'd like to talk about a couple of issues, because I'm sure the representatives from the village will go into more detail about their current concerns. I'd like to flag up that despite there being agreement by council about traffic numbers and safety aspects, this disregards the current residents' views of the junction, the mini roundabout at Grange Drive, the only access of this site. And as recently as knocking on doors over this weekend, this is a consistent view of residents, their fear and their significant concerns about the safety of that roundabout. And sadly, lower down on Spenmore Lane, on the corridor of Spenmore Lane, an absolute vital corridor of traffic, we have concerns at virtually every mini roundabout as far as safety, the number of incidents and accidents that have happened recently. And when we go to the Road Safety Partnership at Lancashire County Council, they haven't really got the capacity, the investment really to address these concerns, and therefore residents have just received standard letters where it says the computer says no, and that the council aren't prepared to reassess that site for another 3 years. This is instigated more recently by the administration at County Council, in that the Cabinet for Highways has requested an urgent review of the Road Safety Partnership and their approach to residents' concerns. I'd like to also touch on education. As a member of the Education Scrutiny Committee at Lancashire County Council, we're not even in a position, even though we're trying to be really, really proactive, to have a strategy that's going to be able to meet the requirements of premature applications. I can't understate the pressure and the anxiety and the inability, because of COVID and lockdown, that premature applications are, how they're impacting on the ability of good, hard-working professional people trying to do their jobs, and also at the same time being able to consult and work with larger communities like our education community, our school community in Chorley on its own. So we're not even in a position to talk about the short-term strategy for school places that the Lancashire County Council are bringing forward as best they can at some speed. It has to come to scrutiny. It hasn't come to scrutiny yet. Not likely to come to scrutiny, possibly, perhaps November and December, and then the decision-making process will have to be timed for. And we really do need that opportunity to engage with the wider school community. You've referenced 4 high schools that have got stresses and strains on them as far as high school provisions. Every single high school in Chorley, and there's 6 of them, not just 4, and you'll appreciate that some residents are having to travel further afield from the 3-mile radius. Every single one of those schools sets their own admission policy and their roll numbers, and it's very premature not to be able to have had those kind of discussions with them about their aspirations, the needs and wants of our communities. And that's why we have a plan. That's why we have a local plan. And actually, it'd be pertinent really to mention that because of all these speculative premature applications, it's put an undue pressure on local authorities actually to be able to deliver their plans on time. And I'm really, really concerned that I want a local plan in place when it should be in place. And if anything, this siege that we're under with the number of applications we're getting to build on safeguarded land, it's incessant. We even had another application in Coppull last week on safeguarded land. You can't underestimate how distressed and anxious local residents are feeling. And when you take away our ability to develop and take through to fruition our neighbourhood plan, our local plan, and being able to, our opportunity to engage with local residents and keep close to them, really what you're doing is taking away the ability of local residents to have a voice. You're making them lack confidence in the whole planning process. They're reading the local paper about inconsistent decisions being made throughout central Lancs area. And you know, we even had our Prime Minister the other day saying that we're no longer building on greenfields, we'll go back to brownfields. And I had residents phoning me up this weekend saying, well, we'll be okay now, we're okay, aren't we? It's not, this means that these inquiries can stop and these speculative applications can just be put on the back burner until the appropriate time, the planned time. And this is the concern of the wider community, and I can't stress it enough. I must thank the very brave, you know, residents that come in to speak in support of against this application. You know, it's not normally what residents do, you know, in the day-to-day life, you know, having to come to it in an arena like this, which is a bit daunting for some people. I get scared, I'm sure. You know, there's a lot of nervous people in this room. It's so important to stand up to support a plan, our plan, a democratic plan. Don't take that away from us, and let's build some trust back. You know, if we're going to build back better, let's build back better some trust in the planning process for our residents. That's all they deserve. Thank you.
Okay, thank you very much, Councillor Berry. Mr. Cannock, is there any comments or clarification points?
No, thank you, Mum. I think you're quite clear on our case on prematurity and the local planning authority's case on prematurity as well.
Yeah, okay. Thank you. Thank you very much, Councillor Berry. I think we have time for another one before we go for a short break. So I think we'll move on then to Mr. Keary. Thank you. Yeah, do you want to sit in the middle so you can be seen in the camera, that's all, because we're being live streamed. Thank you.
Good morning, ladies and gentlemen. My name's Eric Keary. I'm a resident of the Grange Park Estate. I've lived there for 5 years, having moved across from the dark side of the hills. This process I've been involved with previously in the village I lived in, Yorkshire. And it was a wearing time that we spent. It's still going on. This started in 2011. That process is still going on. The residents are still fighting. I'm still hearing what's going on. So, you know, it's just another one of those things for me. I've spoken to most of my fellow residents on the estate, and as you can imagine, from the boundary line through to Spenmore Lane, the feelings change somewhat, or the priorities of feelings change. Particularly on the boundary line, the residents are aghast, and I live on the boundary line, simply because we're going to lose such a beautiful view. That's a very, very personal feeling, and I don't say sorry for that feeling, because that's one of the main reasons I purchased my house. My wife chose the house. We would hate to lose it. We do understand that housing is required, but we also are aware that there are other locations within the borough that could be used first before this one. And this is what we as residents are asking for, that whilst one day it may be built on, does it have to be now? You know, does it have to be in 3 years' time? Can it not be in 10, 15 years when demand is absolutely imminent and required? As you move away from the boundary line, the main feeling is congestion, of increased traffic. I seem to remember from many years ago that each house had 1.6 cars. Now, I think it's changed, and I don't know for certain. But if we take 123 houses, 1.6, we're talking somewhere in the region of 180 cars, maybe a little bit more. going through the narrow straight that is known as Grange Drive, which presently the residents are, because of the growth of their children, having to park not only on their frontages, but also on the road. So driving into and out of the estate is a tricky affair for each of the residents, and we are aware of it. We know where the people park, and we understand why they park. Now, adding to that traffic is going to cause an almighty congestion, and I feel possible incidents inside the estate. We haven't, to my knowledge at this stage, had one, but it could possibly be. Also adjacent on Grange Park is a designated children's play area where the youngsters of the estate actually go and play. Now, that increased traffic could also put them in danger. And it's something I think we should consider both as adults and parents and people who care for the children on the estate. Lastly, the overwhelming concern of all the residents, apart from the individual concerns dependent on where you live on the estate, is the egress and ingress of the roundabout on Spenmore Lane. Now, I will tell you from personal account, that is a very dangerous spot. Only as late as a fortnight ago, and I work shifts which start at 6 o'clock in the morning, so I'm leaving home roughly at 4:30 in the morning. My car was nearly wiped out at 4:30 in the morning by a person who didn't even know the roundabout existed. I take, every time I leave that estate, great care to look to my right down Spenmore Lane, to make sure there is nothing coming. There is limited view, and at some point, I've got to make a determination to move. And at the point I move my head from the right to the left to make sure I can go to the left, that car is on top of me and nearly sideswiped me and took me out. My neighbours can recant the same tale time and time again. That is not a suitable junction for an estimated 180 cars, because if we use the same principle as 1.6 children and 1.6 cars per occupied house, which today I don't think is right, because I can give you infinite numbers on the estate where there's 2 and 3 cars. And I, God forbid, I'm a person at this moment in time, has 3 cars. Okay? So it's likely to be more, and there are going to be more instances. And God forbid, somebody is going to be seriously injured or possibly even killed at that junction.
Just ask you a few questions about that.
Yes, surely.
Mr. Carey. In terms of, you made reference there to a near miss, shall we say, very early in the morning. Presumably that was in dark.
No.
It wasn't dark at 4:30.
Sorry, yes, it was. My apologies, it was,
Yeah.
yes.
So that could have been a driver who wasn't aware of the road and didn't know there was a mini roundabout. I just want to ascertain, I will look at it very much in detail on site. I really want to have a look at that, how that roundabout works, and the parking on road and off road, and the narrowness of Grange Drive.
Yes.
But in terms of general use of that roundabout, if I put it that way, would you say it's worse at certain times of the day or slightly better?
I
Can you
don't think that,
explain
I
a little
don't
bit
honestly
for me?
believe there is a good time. Now, at 4:30 in the morning, when I'm leaving the home, I'm not expecting to see a lot of traffic. In fact, I don't expect to see any. Maybe a milkman or somebody going home, depending on the day that it is that I'm traveling. But I don't expect to see, but even at that time in the morning, I am always constantly vigilant to my right that something's going to come up the hill, round the bend, because we only have a limited view, and I would say it's no more than 15 to 20 yards that we can actually see down the road before the traffic comes round the corner. Now, I know there is a limit of 30 miles an hour, but residents either of or people, and that road is a very good rat run to come through from Chorley onto the Preston Road to go down towards Standish and that way. Most of the people in the village obviously know and respect, because it's such an area. The chap I actually had the incident with was passing through the village, and he was doing, in my estimation, and it is only an estimation, at least 40 to 45 miles an hour. He stopped this much from the side of my car. I did lose it that morning. I will tell you, it's the first time I actually got out, and that's how I know he was from the village. And he told me he didn't know the roundabout was there.
So during the normal day, would you say it's particularly difficult, say between 8 and 9, and when people do the school run, for example, or going to work, and then does it improve slightly as the day
Well,
goes on?
of course,
How
the thing
does
we
it
must
work?
take into account, because this is one of the things that we highlighted at the beginning of this process, this junction, and I don't know where I heard it from, but somebody said that Lancashire County Council Highways Department had done a survey and that there was only 56 cars coming in and out. I take issue with that, plus the fact this was in the middle of the pandemic and most of my neighbours were working from home or at home. I was one of them. So I would say 56 is realistic, but on a given day like today, as we're now being released from the pandemic and people are going back out from work, that number is far more than 56. And I don't think there is a safe time, and this is purely my opinion, a safe time where you can actually approach that roundabout and then without being vigilant and looking both ways, which you should do, but constantly to that right-hand side, there is not a safe period during the day because you just do not know you can't see what's coming around that corner. And it doesn't, whatever they say in the way of speed signs, it doesn't seem to have an effect.
Right, okay, that's helpful. Thank you very much.
You're very welcome.
Certainly, it's something that I'm going to look at when I do a site visit later on in the week. To have a look at that junction and how it operates. Is there any further points?
Just
Mr.
one other
Geary?
thing. When we were purchasing again, this is very personal. When we were purchasing the house, because of the such beautiful view that we enjoy, one of the things we asked was future development. And we were told that there was a covenant, and that was the word used by the solicitor, and I don't know if it is the correct word, that said that it was presently in operation from 2016 to 2026, which meant that nothing could happen. And I haven't been able to verify whether this or what this covenant is, which is one of the decisions we made to purchase the house.
Yeah, that might be referring to the local plan period. I'm not quite sure who said this to you.
This was my
the basis of
solicitor
their
when we were
information,
purchasing the
but,
house, and he explained that, again, this is 5 years ago when we purchased the house, that the land was not up for any sort of construction
Right.
during those periods. Obviously, at the renewal time, things could change. We understood that. And that really concerns me, that either I've been misinformed when I was purchasing a house, or does this covenant mandate, whatever we want to call it, does it actually exist? And what effect does it have on the building process? The last thing I'd like to raise, Madam, is something I heard this morning, which made me sit up and audibly gasp. And I think it was the gentleman to our left here, said the intended construction time was 3 years. Why 3 years for 123 houses? And what effect is that 3 years going to have on the people if this planning application goes through? Those people on Grange Drive are going to suffer traffic of an unearthly type coming through their front gardens almost to get to the planned site. The road just doesn't warrant vehicles of a heavy-duty nature going through Grange Drive and accessing the two sites. I don't understand how that's going to happen. Going into Grange Drive from the roundabout, within 50 yards, you have a right-angled 90-degree turn. It's difficult getting a car around because of parked cars, because our neighbours are parking the cars because they don't have the room, and then wingling your way through Grange Drive. I just don't see them fitting. Where are the cars that are parked on the road going to park when the heavy-duty traffic starts coming through, if it starts coming through? And that's me done, unless...
Right, thank you, Mr. Carey.
Thank you very much.
Mr. Canuck, do you have any questions for Mr. Carey?
No, Ma'am. Again, perhaps just for your note while we're on it, you're aware of the highway statement of common ground, and if you were to, just for convenience, look at paragraphs 4 and 5, you'll see that Lancashire County Council required an update to the TA specifically dealing with junction capacity assessments for junction on Spenmore Lane, and they also required a review of the road safety on Spenmore Lane and a mitigation scheme. And in the light of that, the issue is agreed. I'm not going to pick it up.
Yeah, no, I'm well aware of
Mr.
that,
Kew.
Mr. Cannon. Yeah, thank you.
In
Yeah.
terms of covenants, my instructions are there are no covenants on the site, but in any event, those are private law matters with which we're not concerned, so I'm not going to pursue that.
No, that's
issue
fine,
further.
yeah. I think it, as I said, I think it may be the local plan period that's been referred to, but it sounds like it, but you're not sure, but never mind. Okay, right, thank you very much, Mr. Keary. For a break now anyway, yeah, Councillor Holgate. It's now nearly 20 to 12. So I think we'll now have a short break and we'll come back at 5 to 12, please. So the next person on my list is Lynn Moores, please. Have we got them? Right. Do we want to hear from you first then, Mrs. Keary? Is that going to be easier? Yeah, that'll be helpful. Thank you. Okay then, great, thank you. So when you're ready.
My name is my husband said appreciates the environmental issues that are already discussed and dismissed. However, I do know no bats or wildlife species is the traffic. And the site top of Range Drive. You cannot pass because you get the traffic fully parked on the left hand side as you're leaving the village. It's in that's then people on the front on the pavements. Things there is a roundabout ahead and speed up. It's all been said, so I fully appreciate that. From a personal point of view, I have 2 grandchildren who play on that park area. Even now, we cannot let the kids play unsupervised, whatever age they are. An adult always has to be in attendance due to the speed and the frequency of, for example, delivery drivers. We have upwards of 12 to 16 deliveries, vans coming into the estate and off the estate. Obviously, due to their restrictions and their time limitations, speed is something that really can on the estate. So improve this through this one. So we don't say you cannot leave a child unsupervised. So it is a nightmare as it stands at the moment. Policing, there is an issue of crime within Coppull, with an extra 123 houses. What are the crime-related incidents is that going to be? I understand this is we're getting the additional policemen. However, at the moment there have been crimes on our estate, and police cannot come out to help us. They just give you a reference number. So I dread to think what the increase of the houses is going to do to that aspect of it. And it's something that I don't think has been raised. Car theft, vandalism, drug dealing, things like that. The police have just told us that there's nothing they can do. Greatly concerned where there are children, and it is a young community that so there are quite. It's above my pay grade. Everything that the barristers have spoken about, I fully appreciate that. I'm talking about it purely from a personal point of view. And the reason why the house was purchased, because we thought it was a safe, quiet environment. And I know that's this way. I know it doesn't carry any way.
All right, that's lovely. Thank you very much, Mrs. Keary.
Okay.
Mr. Canutt, you got any questions for the lady? Sorry.
Thank you, Mama. details about the ecological interest, the impact assessments are agreed, and it's likely to be a net gain in terms of positions between us, the unit and the local planning authority.
Yeah,
My-
I'm aware. Thank you.
If I might, is from a flooding aspect. Again, the ecological chain, things like that. But from an environmental point of view, we do get flooding. We could do the backstroke in our back garden when it rains. So, because we back onto the field, what effect is that going to have? So, from that point of view,
Well, again, Mark, I don't want to ask questions. I mean, there is, as you will know, a flood risk
Okay.
assessment at CD 1.8.
Right, thank you very much, Mrs.
Okay.
Carey. Can I just ask the local authority, can you check that microphone, please? Because there seems, I don't know, it's some vibration or some feedback or something on there. Or maybe we use a different one. I know it was, it's, maybe your animal magnetism, I don't know, Mrs. Carey. Thank you. Anyway, we'll continue anyway, and hopefully we can resolve this later on during the day. Mrs. Moores, please. Glad you were able to make it back to us.
Hi, I'm Lynn Moores. I have been a parish council for the last 2 years, but today I just want you to think about me as a resident. I've lived in Coppull now for 50 years. My parents moved to Coppull in 1968 at a time when there were far less housing than there is now. And we've seen so much be developed over the years, and the village, you know, has grown. What is it hard for schools? One pharmacy, in fact we had two and now we're down to one. You refer to this field as BNE3. The people of the village refer to it as Blainscough Fields and Nature. And it's stunning. It's not just personal to the people who live directly in the estate, it's personal to the entire village, and there's greenbelt there for good reason. I moved on to Grange Drive 15 years ago. The perfect house for us, disabled son. Accessibility was brilliant. We didn't have to make any changes to the house itself and doorways and whatnot. And we always knew that in the future we could change one of the downstairs rooms to a bedroom when the time comes, and that's what we've done. To the front of my house, I've had the council drop the curb because my son needs to get access to the house. We have one drive, we have two vehicles. And even when Oliver was being picked up from school, the road at the side of us is not wide enough to get two vehicles down. So a great big minibus would have made it difficult for anybody, and he had to park up front. So that was another reason for the drop curb. Oliver's got cerebral palsy, and he has an electric wheelchair. He has support to his head. Don't go feeling sorry for him at this point with his disability. He's gone into his third year of university. This is one lad who's going somewhere and gets involved in Lancashire County meetings and rights for disability and provision in education and the like. So he's going places. But where we live has been significantly brilliant for him to grow up with accessibility and the likes. That said, in the morning when he was being picked up, we had to be really, really careful because the amount of traffic coming through has meant that people have had to be aware of him being there. He's had to come off the curb, he's had to go out into the road, he's had to turn his wheelchair, had to get up the ramp into that vehicle. And the same applies with the vehicle that we've had adapted on a daily basis when Oliver's home. So the road at the side of us isn't wide enough to get two vehicles down. The road at the front of us it can get two vehicles down. But I can tell you that the farmer has had to knock on my door on numerous occasions to ask us to move the vehicle because he's been worried about when he passes with his tractor and his trailer. So when construction vehicles are going to be coming down our estate where I live, on the corner, where the road chicanes and traffic comes speeding through, regardless of the fact there's a 20-mile-an-hour sign, I do worry about, has been raised, that there are residents who do have to park on the road. We have to park on the road. How those vehicles are going to get through. There are currently 100 houses on Grange Drive, 100 houses trying to get through this roundabout that you've heard about that is got really difficult visibility. Putting aside this new development, this prospective new development, it's been difficult enough for those 100 houses with up to 180 to 100 vehicles coming out of that estate at any one given time of day. You may not be aware that when the estate was first built, there used to be a listed building at the site where the roundabout was put. Just to the back of it was a farmhouse, and it was dropped illegally, and the developers were fined for doing so because they didn't want to build where they could have built the roundabout, they could build 4 townhouses and make more money, which shortened the visibility of that roundabout. It could have been across from Tansley Avenue. I don't know if you're aware of the demographics of the area, but it would have been a perfect roundabout across from Tansley Avenue. We now have literally yards, 20, 30 yards visibility before the road sharply goes to the right and in the dip where the wood yard is. And literally, you are on that roundabout when leaving it before you can see, or the people coming up the hill see, any vehicle on that roundabout. And it does come as a shock to some people because they believe from what they can see, where the road widens for them to approach the roundabout, that nothing's going to be coming to the left-hand side. And you have to be on that roundabout to make your claim. You cannot see 3 car lengths down. And of course, that would be if they were coming up at 30 miles an hour. Quite often, because they're leaving a village, they're ready to leave a village and just keep going. On top of that, to the left-hand side, there is a bus stop and a traffic island, and traffic parked up behind the buses that stop because they can't pass, and signs to say so. So you've got traffic getting a little bit frustrated on that side, wanting to move. And quite often I've been on the roundabout when traffic, literally on the roundabout, when traffic has tried to come from the left-hand side also. This is common, this is every single day, and it does not matter what time you're coming off that estate. My husband leaves at 7 o'clock in the morning. It happens then. I leave between 8:30 and 9:20 because I have to take my daughter to school in Chorley. I had to take her to primary school in Chorley, incidentally, because there wasn't any places for her to be in school. So at that time, when it's busy, there is traffic coming from both directions of people anxious to get to where they're getting to, work and school. And then through the day, because the nature of how marketing and shopping's been these days, we've got couriers on and off the estate all day, every day, up to 7, 8 o'clock at night. And where I live on the corner, I see vans coming, reversing up the side of my house. I hear them because they're beeping. I see them because, mounting the curb to turn the corners and whatnot. And it's all the time. I've had 2 pets killed at the front of my house as a result of couriers. There is no consideration. A 20-mile-an-hour sign doesn't mean much to somebody who's got to get from A to B. But there are 100 residents on that estate that have to deal with this on a daily basis, as well as getting from A to B themselves and parking. Directly across from my house there's a play area. A play area with a very, very small fence that's not been maintained, where children can run out from that play area across the road where, I'm going to guess right now, because I'm sort of in the middle of the estate, that I'd say half of Grange Drive and all of Manor has to pass. So you've got children who are crossing the road there, and they have to cross the road to get to that play area, which is central to the estate, who are at risk of the people who currently live there and people visiting and couriers. An extra 123 houses. That's more than double the traffic that we already have trying to get on and off the estate that has poor visibility at any given time of day, where you literally, as I say, have to claim that roundabout and be on it before you can make a decision of where to go. I used to drive a rather large Jeep. It was really handy at the time because anything that used to come side onto you, I could kind of just look down at. I'm in a smaller car now, and it's quite scary. And you do get this kind of look of why are you here? Because they feel they have a right to that road, but it's a roundabout. And once on that roundabout, you have right of way, but it means nothing to the people trying to get from A to B as quick as they want to. So that's the traffic issues. I've lived on the estate 15 years, and I've seen the effects of rising water and flooding on the estate. The top field, if you will, which is to the right of the public footpath, the field literally pools. It has a lake in the middle of it during any wet period. In the winter, if we have hard rainfall, that increases. And under the footpath itself, there is a drain that flows under Grange Drive to Tanyard Brook. That backs up considerably, and it is gushing. Sometimes it's a good deep drain, I'll give them that. It's a small pipe, and you can see the force with which that comes through. I've seen the pavements on adjacent to Tanyard Brook literally come open. It's breached, it's broke through the footpath. The drain's gushing. I've seen what was a brook literally look like a river with incredibly fast water flowing. That brook runs into Clanket Brook further downfield. It has to go through Tanyard Close, which is a low-lying area of housing. From Tanyard Brook and Clanket Brook, it goes into the Yarrow, and that goes on to Croston. And anybody knows this area demographically, Croston is an area that year on year suffers with flooding issues. They've had the army called in to deal with it. It's not minor, and water has to go somewhere. So if we've got this problem of pooling in a field that's on a slope, that's going to a brook, that's struggling to get through drains, you put houses on that estate, more than what we have existing there, you are going to raise them water levels. Yes, the Environment Agency have been out and they'll say it's great now. What about 2, 3, 4, 5 years down the line? Chorley have got a climate emergency going on. We know water levels are rising. We know. Then you've got Blainscough Nature Reserve, which is at the side to these fields and the woods, which is an area of significant wildlife. Yes, there is bats. Yes, there are squirrels. Yes, we do have birds of prey. Yes, we have had deer there, as well as all the small creatures. And that field that they plan to build on is a field that I have seen and hear birds of prey feeding off. They don't do it in fields. They work from above. What's down there is what they feed off. So for the wildlife, it's significant. As I say, they call it BNE3. We know it as a beautiful area, not just pretty to look at from the houses, but important for people who go there for leisure. There's a public footpath that runs through. There's a few public footpaths that run through, and you can get to literally any given area in the village from that point. And I see lots of people walking by my house, not just during lockdown. You've got families walking, you've got dog walkers, who again are going to be at risk if there's going to be an increase in traffic. It's significant. We've got Blainscough Hall there, and I'm going to focus on this because we've done a lot of works, for instance, to Astley Hall recently, and we're looking at our heritage in the area. Blainscough Hall is a hall that's hundreds of years old, goes back to times of Oliver Cromwell, where priests used to hide out there. It was a moated house. It was of significant value, and it's of significant value heritage-wide, and we're very proud to have these areas. We've got areas like that in Heskin, we've got it at Astley, we've got it in Coppull, and we should focus on those areas. We should be looking at grants for keeping those areas the way they are. It's also right on Greenbelt. Ask yourself the question why they've called this development land adjacent to Blainscough Lane and they haven't used Blainscough Lane as access. And the reason for that is because that lane is right on Greenbelt. And to develop that road and the drainage on that road, it's going to affect the Greenbelt. They're going to have to cut into it. It would have been, if it was allowed, probably the safest way to get into the estate. But instead they've chosen to come into an area that they know they can use, and it's going to affect 100 people living on that estate already. It's not the common sense option that they know they're going to struggle with to use Blainscough Lane. And now I'm going to talk about prematurity with the neighbourhood plan. As I say, I've lived in that village 50 years and I've seen a lot of developments. A few years ago, a couple of years prior to lockdown and COVID, we had a developer decide they wanted to build near Burkacre, and which is the jewel in the crown of our area, throughout Chorley, not just Coppull. And it would have been where the fish pass and the waterfall was, and it was significantly stunning and beautiful, and an area where people come from Liverpool and Yorkshire and whatnot to come, and the prospect of someone building an estate there with great big fences, you know, what would have, you know, been an area that people have, from the Industrial Revolution onwards, used as an area of natural beauty after it was all sort of, you know, made as such when that sort of came down, as an area where people have used as leisure and gone as families for as long as I've lived in the village. The thought of losing that was upsetting to the village. And when it was discovered that they were going to do a consultation meeting in our community centre in this tiny little room, word got round within an hour. And I can tell you now, there probably would have been about 200 people that had heard about it on social media turned up in that room. I was one of those people. We found it quite insulting that there was this tiny little room where we meet now as a parish council, which just about fits 15 of us in, to discuss what they were going to do there. And I actually removed what they had on the tables and took them upstairs to a great big room that we had for the public. I said, let's hold the meeting here. Lots of people came down, there was lots of objections. And I will say to you that from probably that point on, we started to realise as a village that what we relied on as safeguarded land and our village plan was a threat. So it's not premature, it's years old that we felt we needed to do something about it. And from that point on, there's been various forums and sites and committees that have come together to try and, you know, establish something that we could say, can we at least have a say or part of the planning in our village to stop this happening? But these are this and another development that went in last week are areas of safeguarded land, as I say. And safeguarded doesn't mean that come 2026 we will build on that land. It means if it's possible, if there are amenities available. And as I say, in the 50 years I've lived there, it's 1 doctor's surgery, 4 schools, 1 dentist, and we've just recently gone down from 2 pharmacies to 1, and it's caused havoc with people who've needed literally life-saving medication that they've had to wait days for. Building this estate and having another 123 houses, which doesn't mean 123 people, of which at least half you're going to say are families who are going to rely on the schools and the GPs and the dentists and everything in that area. As a village, we're just not ready for another development of this size and the ones that they've got lined up to come after it. Because I can tell you now, if this happens in this area where it clearly shouldn't happen, it will open the floodgates for many, many more. And I do know that, you know, the farmer, Mr. Dickinson, who has a claim in that land, also has a claim in the next development, and he has huge fields. He has made it quite public that he intends to fill them with houses. You let this happen, that will open the floodgates for the rest. There are other areas adjacent to where we live that are suitable for development. There will be people who will contest that, but I can tell you now there are greenfield sites that have gone to brownfield that have again returned to greenbelt that could be opened again. And I'm going to say the word, it's Camelot. If it was big enough for a theme park, it's big enough for a housing estate. And why that can't be built on, I'll not know. It doesn't affect the village itself. It doesn't affect any of the villages the other side of the motorway. It's got the road structures in place. It coped with it before, it can cope with it again. Right, heritage I've covered. I'm just going to quickly look through my notes in case there's anything I've missed. The construction vehicles. If a farmer can't get through and struggles, how construction vehicles get through? 3 years of it, it will be hell on earth for the people who live on that estate. I'm going to touch on the area, the subject of crime. The police were aware that that roundabout wasn't suitable, and they tried to put their bit in. And as Julia said, Lancashire County Council say the funds aren't available. So I'll jump off crime, sorry, I'll go back onto that. If this was to go ahead, if there are no funds available, how can you make a roundabout that's unsuitable for people who currently live on the estate to provide for double that number and double the cars to come on and off that estate? And I'm sorry, but a few signs that say, please slow down, there's a roundabout here, doesn't structurally change that roundabout. It doesn't structurally open visibility. It doesn't change that it's dangerous. It doesn't change that people have to literally be on that roundabout in the same way you put your foot on a zebra crossing on a vehicle. but a zebra crossing is far more obvious. And we've got this, as I say, throughout the village with a few mini roundabouts, but there's not about to be 123 houses built next to the others. That's another story. Crime I will go back on. I live in an area where I see people come on and off the estate. We have got local drug dealers who are open about their transactions. From the point we can hear them when they're coming on the estate, shouting on the mobile phones, doing transactions next to the play area, in front of the houses. The police are aware of it, and it doesn't seem to be something that wants to be dealt with. If you're going to build another 123 houses where it is known where criminals use an area to get to other areas of the village, and it gives them another sort of network, a warrant to do the dealings in further away from the main road, all I can say is it's inevitable there is going to be an increase in crime. And that scares people who live on the estate because it's not being dealt with at the moment. It worries me. Like these people who've moved in and they've been there, 5, 10 years, 15 years, and I'm on that estate, and I've been in the village 50 years. I did look at the public plan, and I did see 2026, yeah, that's fairly reasonable, and I know the amenities aren't here, so it's very unlikely they'll build. And I'd put it to you, and I put it to everybody in this room, that this development isn't about supplying houses to people who need houses. It's about greedy developers who are taking advantage of a loophole that's become available recently to them, which is in itself premature, if you want to talk about prematurity, to existing plans that have been put in place to stop that from happening. And the councillors are right, that they work on this, and they had this belief that this was the way it was going to be, and things are coming in thick and fast. There's been 5 areas that have been applied to recently and knocked back by greedy developers who prematurely are jumping in at a loophole they can see, and the people working on this can't work fast enough. And you're tying us in with Preston and South Ribble. You only have to look at areas like Buckshaw that have come into the area. There has been a massive amount of housing that's come into the Chorley area, more so Chorley than Preston and South Ribble. Why are we not pushing this further aside? Why are we looking at villages that have grown so much in size, that have been squeezed to the point where they just can't cope with what they've got, where there is no provision to the same 4 schools, as say, same doctors, same dentists. You put another few hundred houses on, there's not going to be more of that. And people are genuinely now already taking the children to schools out of area. And you talk about climate change, and you talk about doing your best for the environment, that's more cars on the road going further. And what about people who are in low-cost housing who can't afford to take the children out of the village to go to schools and GPs and dentists? We live in an area where we are split-level transport provision. We rely on something that's in Coppull, that's part of Greater Manchester, not Lancashire. And the children and the families in our village are actually paying a higher rate than everywhere else. So if they're to go to schools in Chorley, or GPs and dentists in Chorley, it's £5.50 for an adult a day to do that, and £3 odd for a child if they've got more than one child. £10 plus to go to your doctors, or your dentists, or your school is just ridiculous. They should be able to go to schools and doctors and dentists in the village. This is massive pressure, and the response with the neighbourhood plan isn't because we want to pick on one particular development. It's because we've recognised for years that there is a need to take some responsibility and be part of some of the decision making, because the very people that we've trusted for all these years to be able to do it, it's been taken out of their hands. They can't do it. So we really feel we need a voice. We really need, that our safety should be taken into consideration. Our amenities should be taken into consideration. Where we want to raise our children should be taken into consideration. And it just seems that it's almost like pie in the sky of, well, there's an area, we'll just shove it there. They don't live there. They do not live there. They don't see how it affects people day to day. And this is why I don't want you to think of me as a parish councillor. As I say, I've represented the village and listened to concerns for 2 years, but I've been a resident of that village for 50 years. And I've seen many, many developments come, and I've never seen one as ridiculous and absurd as this particular one. As I say, the entrance to it isn't where it should be, and they know it's because they cannot, the law won't allow them to enter that estate that way. So they're picking on this already dangerous junction to be able to do it. And if it gets passed, it's going to double the issues that we have. It's going to, in traffic, in crime, in flooding, in safety, in peace of mind. And I can honestly see that the people living on the estate are going to start thinking, is this the place I want to live? I've even thought about it after living in the village 50 years, and that actually makes me I feel with dread with that thought. It's sad because I've always lived on the outskirts of the village. I used to live down Clancott Lane. I've lived for a short time centrally, and I've lived on the edge of this village because it's a place I played as a child. It feels I crossed as a child, going from one school to the next. It's, you know what I mean? It's not just beautiful, it's part of my growing up and my upbringing. And to see this area of safeguarded land next to Greenbelt be at threat and know that this will open the floodgates for more to be done, it fills me with dread and makes me wonder whether I want to live in this village I've lived in for 50 years and that I, for the last 2 years, represented and listened to the concerns of residents. And so I dread to think how high that number would be for people who've lived there a long time or people who've lived there for a short time and don't appreciate it perhaps the same way, but wanted it to be the case because it is a beautiful place to live. So I urge you, please, to really consider whether this is just an opportunity for greedy developers or whether it is a sensible option for housing in the area when there are so many other places it could be.
Okay, then thank you very much, Mrs. Well. That's very helpful. Mr. Cannock, you have any questions or you content? Right, thank you very much. Okay then, well that concludes all the interested parties who want to speak today. I am aware of a couple of other people who aren't able to be here today. I think that's Mr. Winstanley. I think it's Councillor Hilton, I think. They're going to come on Wednesday, I believe, so we'll hear from them then. We'll fit them into the programme. Sorry. That's what I understand it. It's with the Mr. Winstanley. And then I think there's Councillor Hilton as well, I think. Wednesday. Okay. All right, thank you. Right, I want to move on now to my questions in relation to 5-year housing land supply. Now, this basically relates to the various sites that the council have included within their supply, and there is dispute between the parties on whether some of those sites will deliver as the council envisage. Now, I have before me a housing land supply roundtable area common ground, statement of common ground, and that sets out a number of agreed points. Just in brief summary, those relate to the base date for the assessment of the 5-year housing land supply. That is from the 1st of April 21 to the 31st of March 2026. It's also agreed that CAL Strategy Policy 4, which sets out the housing requirement for Chorley from 2010 to 2026, is 417 dwellings per year. And that was reviewed less than 5 years ago in 2017, and that the council then entered into a memorandum of understanding with neighbouring authorities of South Ribble and Preston, endorsing continued use of the requirement in Policy 4. Yeah, Mr. Crew, do you have a question? No. Not at all. No, if you need to go, that's fine. Yeah. No problem, that's fine. You just go if you need to, that's fine. Okay, thank you. Right, we'll just wait a few moments. Okay, you're welcome. Okay, so also in the agreed statement of common ground, if we apply the standard methodology calculation, it is agreed the annual requirement should be 537 dwellings a year. It's also agreed that the oversupply set against the adopted housing requirement is 1,567 dwellings. I take Mr. Cannock's point about whether we should call it oversupply or over-delivery or whatever phrase is appropriate. There's also agreement that based on the housing delivery test, that the buffer should be set at 5%. Now that's all quite technical, and that's all really about the different methodology of how we calculate how many houses are required to be built over a 5-year period. What we want to look at now briefly is the supply. In other words, how are all these houses going to be built? Where they're going to come from? And there are sites that the council has put forward in their supply to provide all those houses. And there are some disputes over whether or not they will deliver as envisaged. So disputed sites without planning permission. There's a site at Eves Green off Lower Burr Way, which I believe it is agreed that that should be reduced by 40 dwellings in the 5-year supply. The evidence I have before me doesn't indicate why that is the case. I think it's agreed, there's no dispute. But can I just briefly ask why that is the case?
It's a question of reviewing the timing of delivery, and in effect, I think the parties agree that the timing of delivery needs to be pushed back when compared with the assumption in the 5-year housing land supply statement last produced by the council, and that leads to the loss of, if you like, 40 dwellings off the end of the process.
Right, okay, that's helpful, thank you. That's only a brief question on that one. Can I turn now to site HSG 1.5, Cowling Farm? Now, this site in the 5-year housing land supply, I believe it's a site for 158 dwellings. And currently there are 80 dwellings identified in the 5-year supply. The appellant has challenged whether or not this site is going to deliver. And can I just turn to Mr. Cannock, or Mr. Cannock's team, Mr. Saunders possibly, can you explain to me why you have come to the conclusion you have? I'm not quite sure how they work myself. They are charged. You have to charge up, I believe. But it'll be adequate for now, put it that way.
Hopefully that's...
So, yeah, so either that or shout, one or the other.
Yeah, no problem. It was based on some contextual points. Sorry. Yeah. Yeah. Yeah, there's 2 points really. One's contextual, based on the council's previous monitoring reports on how the site will be delivered, which in our view sort of flags some uncertainty on the deliverability of the allocation over the next 5 years. We flag it in our evidence, paragraph 7.12 of the housing supply proof. But just as an example, the 2020 housing supply statement, monitoring supply statement CD 6.13, appendix 2 provides a breakdown of the strategic allocations and their delivery. In the 2020 assessment, from 2020 to 25, the council claimed that 158 sites will be delivered up to 2025. But in the space of a year and a half, in the updated 2021 assessment, CD 6.15, that figure's only 32. I think from our point, we've just flagged that, you know, obviously there's a significant reduction, and there's been no further evidence in that period or justification to sort of explain to support the deliverability of the site. So there's a contextual point that we've flagged, pointing to the lack of evidence to support delivery, and we've also set out in our proof our view on anticipated timescales in terms of application submissions and various lead-in periods, which we believe, I think we've contended the first completion would be March 2025. Hopefully that provides a summary of it.
Right, okay, so in the 5-year supply, as put forward by the council, this site provides 80 dwellings. So in your view, how many dwellings will this site contribute towards the 5-year supply?
We've contended that it wouldn't deliver in the next 5 years.
Again,
We don't believe it will deliver any dwellings in the next 5 years.
won't deliver any at all in the next 5 years. Right. So does that lead us then to take 80 out of the 5-year supply?
Yes, that's part of our reduction. Based on, yeah.
Can I ask the question then, in your this document, the housing land supply proof of yours, on page 57, you talk about a reduction of 60 dwellings from supply. The maths don't add up, so that's my question really.
I had actually just noticed that going through this morning, so apologies, that may be a typo error. We would put it out as 80. When you go through the comparison positions, I can try and direct you to the...
The numbers are quite finely balanced and they don't really make a great deal of difference in terms of the supply.
Yeah.
But it's just so I understand
That's
the
right. Yeah,
calculations
we
and
would
how
say
they've
80.
arrived at.
Yes.
So you're saying 80 dwellings should be taken from the Cowling Farm site.
Yeah.
You've also then got 40 from Eves Green.
Yes, that reflects the accepted
Right.
position.
So in terms of sites without planning permission, there should be a deduction of 120 then. Is that right?
Yeah, there's a slight point of clarification. I've based the reduction overall based against the, again, just for clarity, against the 1564 figure within the 2021 housing supply statement.
I see, right.
And it takes it from there.
Right, so you're not taking it off the,
No.
yeah,
No.
that's where the difference lies, yeah, I'm
Yeah.
with you now, right. Yeah, right, I understand that. I was wondering why you're taking 60 off on your table 10 on page 58 of your proof and not 120 or whatever the figure should be. Right, okay, I understand that. Yeah. Less another 80. Right, so it's 1565. Right, okay, that's helpful. That clarifies the figures, yeah. I just didn't quite add up for me. So I just wanted to make sure I wasn't reading it wrongly or whatever. Yeah. Okay, thank you for that. Right. So then, moving on with the council then, your council's view, are you still confident on your figures? Or?
Eves Green agreed.
Yep.
Cowling Farm, not agreed. I think the position is an allowance was made for 80 in our most recent 5-year housing land supply assessment. There was another inquiry that took place several weeks ago, virtually, but in Chorley, where this same issue cropped up. The council looked again at that site and agreed instead of 80, it should be 60. And we maintain that an assessment of 60 units delivered over the next 5 years from that site is a fair one. In very broad terms, madam, it's a Homes England site of which they have entire control. There has been some dialogue between the council and Homes England, and according to Homes England, they remain committed to the development of the site. They have experience in this area and there's no reason to doubt it as far as we're concerned. If you want some more detail as to the position of Homes England, then I'll have to hand over to somebody else to give it.
No, that's fine. I don't need any more detail. As I said, we all appreciate there are, on the margins, these numbers anyway, they are reasonably close. It doesn't make a great deal of difference because the supply is potentially less than 5 years if you don't take account of oversupply or over delivery anyway. So, yeah, so that's fine. So in effect, what you're saying is taking 20 from the 80. So it's 60, it will contribute 60 to the 5-year supply. Yeah, okay. Okay, I understand that then. Good, thank you. So if we move on to the other sites that are referenced then. Windfall site of more than 10 dwellings with planning permission. This is Fairclough House, which is suggested will provide 56 flats, 56 units in the 5-year supply. And there is debate over whether or not that will be achievable, bearing in mind the fact that the permission, if I call it that, has only just over a year or so to run, whether or not it will be feasible for it to be implemented in the time frame. Is that basically your position, Mr. Saunders?
Yes, ma'am.
Yeah, okay. So can I turn to the council then for clarification on why you feel that site is still appropriate at that level?
And again, I can summarise, hopefully I can accurately summarise our position. That site, in effect, has a detailed planning permission. And adopting the definition of deliverable in the glossary to the framework, it tells us that it should be included in our 5-year supply calculation unless there is evidence to the contrary, and there isn't. Other than the simple observation about how much time is left to run in terms of that consent, there is no evidence to suggest that it won't deliver. It's a conversion of an existing building that exists. So we say adopting the approach set out in national policy requires its inclusion.
Sorry to interject. It would have to be within the next year, so 21, 22. Yeah.
They all benefit from detailed consent. And I think an allowance is made for certain windfalls to fall by the way in our 5-year supply assessment in any event. So for whatever difference it makes, and it's highly marginal, that's our position. And Madam, can I just, in terms of the materiality of the difference between the parties, even if you add up the entirety of the contentious supply sites, the difference is, I think, reasonably marginal, both in terms of the actual figures, but also in terms of years' worth of supply. So I think I gave the figures in my opening remarks as to the position if you adopt our approach of policy 4, plus taking into account oversupply, the difference is 1.2 years worth of supply between 12.6 and 13.8. Assuming you adopt only policy 4 without oversupply, the difference is 0.3 of a year. And assuming you adopt a local housing need figure based on standard method, the difference is 0.2 of a year. I don't think either party is going to be telling you that once you've decided on one of those 3 approaches, that difference is going to make any difference to the outcome of the appeal. That's certainly going to be our position.
Very usefully done, a quick summary at the end there of the position and the differences between the parties. So I'm content with that element for now.
And Ma'am, just on that, if you look at table 10 on page 58 of the housing land supply proof of evidence, you see a convenient summary table. I'm sure you have that. And
Yes,
I would
got that, yeah.
and I would echo and endorse Mr. Ponter's last point, I set out our position in opening. We don't consider the issues regarding deliverable supply to be material, the 2.4 to 2.6, 3.1 to 3.4, etc., etc.
Yeah, no, that's accepted. Thank you. Right, so that's all I need to do on that particular aspect. Bearing in time that time now is 1:45. I think we're probably at a point where it is most prudent to take a lunch break now rather than continuing till 1 o'clock. So what I think we'll do then, we will take a break now. Are we content with an hour for lunch, or do we want an hour and a quarter? Any preference? Well, we'll just take the hour then. All parties are already here. We don't need to wait for anybody. So we'll adjourn then now for lunch, and we will return at 1:45. Then we'll start with the council's evidence with Councillor Wilson. Thank you, everybody. Right, thank you very much, everybody. The time is now just after 1:45 and we are resumed. So this afternoon we are going to start hearing the council's evidence. I'm going to invite their advocate, Mr. Ponter, to introduce his witness. Thank you.
Thank you, Madam. Councillor Wilson, just going to ask you to test your mic. That appears to be working.
Should be working.
Thank you. You've produced a proof of evidence and a summary proof. Let's just introduce you from your main proof of evidence. I'm looking at page 2, headed Introduction, where you tell us that you're Councillor Peter Wilson. You've been a councillor in Chorley, I think, for 13 years. You're the deputy leader of the council, is that right?
Correct.
And you say that you were involved as a councillor, a member of the executive cabinet of the council in preparation of the adopted Chorley local plan. You're familiar with the issues raised in this appeal through regular briefings to the leader of the council and yourself. What's not covered in your proof in terms of your experience is your inquiry experience, which includes another inquiry held relatively recently in respect of appeals for 2 sites known as Tinkler's Lane and Town Lane, where broadly the same issues, certainly in respect of housing land supply, were considered. We were waiting the decision letters in respect of those 2 appeals. Did you give the evidence on behalf of the council in that inquiry?
I did indeed.
Albeit virtually. Right. Okay. The inspector has indicated that she's read all of the evidence, including yours, so I'm going to take that as read. What I want to do is deal with some of the main issues with you in your evidence in chief. We know that you're the first witness to give evidence on these points in the inquiry, so I want to take a little bit of time going through some of these points with you. And they're the ones relating in particular to the question of housing requirement, which is at the centre of the case. So let's start, please, with some policy and the National Planning Policy Framework, which is CD 5.1. Well, what I'm sure won't be the last time in this inquiry, paragraph 74. Which appears under the heading Maintaining Supply and Delivery, and tells us in the second sentence that local planning authorities should identify and update annually a supply of specific deliverable sites sufficient to provide a minimum of 5 years' worth of housing against, and this is the important bit, their housing requirements set out in adopted strategic policies, or against their local housing need where the strategic policies are more than 5 years old. And there's no dispute, as I understand it, Councillor Wilson, that the strategic policies in this case include Core Strategy Policy 4, adopted 2012, are more than 5 years old.
Indeed.
Of course, a couple of footnotes attaching to that sentence that I've just read out, including footnote 39, which is the caveat to the requirement to use the local housing need figure. We can see in footnote 39, unless these strategic policies have been reviewed and found not to require updating. You see that?
Yeah.
Just so we're clear, what's your position as to whether or not the strategic policies, in particular policy 4 of the core strategy, has been reviewed and found not to need updating?
It has been reviewed, reviews undertaken in 2017, and those figures were found to be adequate, correct, and not in need of further update.
We'll come to the 2017 review in a moment or two, but I think the document has been named MOU1, that's the acronym at least, Memorandum of Understanding number 1, and that was 2017.
It was.
So I'll come back to that in a moment or two. You can close down the National Planning Policy Framework and turn up its accompanying planning practice guidance. Now, we've got various extracts of that amongst the core documents, and the bit I'm interested in is at CD 5.5. a section dealing with housing supply and delivery. And if you could turn within those extracts, I'm looking in the bottom right-hand corner for page numbers, 3 of 21. And that says, under the heading, what housing requirement figure should authorities use when calculating their 5-year housing land supply? Housing requirement figures identified in adopted strategic housing policies should be used for calculating the 5-year supply figure where the plan was adopted in the last 5 years or the strategic housing policies have been reviewed within the last 5 years and found not to need updating. And then in other circumstances, it's the local housing need figure. So, again, so we're clear, is it your position that we fall within the first part of that provision, namely housing requirement figures should be used in strategic housing policies? Certainly not when the plan was adopted in the last 5 years, because it hasn't been. The second bullet point, the strategic housing policies have been reviewed within the last 5 years. And just so we're, again, clear about this, do you understand there to be any dispute that what took place in 2017 that culminated in, I'm going to refer to it as MOU1, just to, in the interest of speed, do you understand there to be any dispute that what took place there was anything other than a footnote 39 review?
No, there was no dispute that this constitutes a footnote 39 review.
All right. Next, please, let's turn to some appeal decisions. There's a whole host of appeal decisions amongst the core documents in this inquiry. I want to look at 3 of them with you, one from each of the Central Lancashire Authority areas. And the first of those is from Chorley, and it's CD 9.1. This is the second of 2 decisions concerning a site at Pear Tree Lane in Exton. Have you got that?
Yes.
It's dated the 11th of August 2020. And it was appealed in respect of a scheme of up to 180 dwellings. We can see that in the header to the decision letter. And at paragraph 1, we can see that the appeal is allowed. Turn on in the decision letter, if you would please, to the 4th page. Where there's a heading, housing need or requirement. And one can see at paragraph 16, reference to what was then footnote 37, now footnote 39, under the current revision to the framework. Reference to footnote 37, and that paragraph concludes by saying that the main parties agree that as at the 1st of April 2020, the minimum local housing need for Chorley, calculated using the standard method, is 569 dwellings a year. Do you see that? Yes. That's where the figure for local housing need is identified there. Paragraph 17 then refers to a second memorandum of understanding entered into in 2020. For shorthand purposes, we're calling that MOU2. And the inspector describes what that did. It aggregates the minimum annual local housing needs standard method figures for each of the 3 Central Lancashire authorities and redistributes them across the Central Lancashire area. And it relies in doing that redistribution on the Central Lancashire Housing Study of March 2020. We'll come back to that document in a moment or two. So MOU2 and what it did is described in paragraph 17. And then at paragraph 18, the competing figures that were before that inspector are there set out. for our purposes, if we look at the table, find Chorley in it, which is the first entry, we see, like, the solar standard method figure for Chorley given of 569 dwellings a year, the figure we saw earlier, and the redistributed standard method figure, which ended up for Chorley at 278. There was, if you like, a shift of that need in the direction of Preston and South River. And then at paragraph 19, the case is summarised before that inspector, and that inspector says that the main parties presented the two alternative figures for Chorley as a binary choice in this case. So either the solar standard method figure or the redistributed standard method figure, 569 or 278. That was the binary choice before that inspector. Do you understand that any party to that inquiry suggested to that inspector that the policy 4 figures as endorsed through MOU 1 should be used? No. Just to complete the point on this decision letter, I think if we turn on to paragraph 32, Councillor Wilson, just to identify for the inspector's note where the inspector's conclusion is reached. I don't take you through the reasoning, but if you look at the last sentence on paragraph 32, the conclusion, which is that limited weight should be given to the housing requirement figure for Chorley of 278 dwellings per annum. So the redistributed figure argued for by Chorley given limited weight. And at paragraph 33, the other side of the coin, which is that the 569 figure, the solar standard method figure, should be used for the purposes of calculating the 5-year housing land supply. Now, following receipt of that Pear Tree Lane decision letter that rejects MOU 2 as the basis for setting the housing requirement, applies the standard method figure, has Chorley sought to rely on MOU 2? No. Let's see if anyone else has sought to rely on that. Turn to the next appeal decision that I want to take you to, and that's in Preston, CD 9.4. This is a site known as Cardwell Farm at Barton. Now, Pear Tree Lane, August 2020. We're now into 2021, 9th of March. Inspector Dakin's decision on a proposal for up to 151 dwellings at land at Cardwell Farm. Let's just see how that inspector deals with the weight to be given to MOU 2, and I think it's paragraph 36. Turn on to that. Page 6. You should see reference to MOU 2 and what it did, and then in the third line, the veracity of MOU 2 was tested an inquiry in the summer of 2020 relating to a development of up to 180 dwellings at Pear Tree Lane. The inspector in his decision gave limited weight to the figure for Chorley derived from MOU 2 because it was outside the local plan process. And then he says he noted that PPG allows the housing requirement for a joint plan making authority to be distributed across the plan area, but this should be done through the plan making process, not through decision making. I agree with this analysis, and that footnote then 37 effectively provides two principal options for a local planning authority housing figure, either strategic policy requirement or the local housing need figure. Accordingly, do you understand this inspector to have placed any significant weight on MOU 2? Did either of the parties, as far as you're aware, ask this inspector to place any significant weight on MOU2?
No.
I think noting in particular the Preston City Council's position on MOU2, again for the inspector's note, paragraph 39, does that tell us anything about Preston City Council's position with regard to the continued utility of MOU2?
No, again, that not being relied upon.
Thank you very much. And so the binary choice presented to that inspector, recall the binary choice presented to the Pear Tree Lane inspector is either the solar standard method figure or the redistributed standard method figure. Was that the same binary choice as presented to this inspector or a different one?
No, different.
So I think here we have either policy 4 endorsed by MOU1, which is what the appellant was arguing in that case, or the solar standard method figure for Preston, which is what the council was arguing for.
Correct.
Which did the inspector prefer?
The inspector went with the policy 4.
Paragraph 40, I think, is where that conclusion is set out, which concludes, therefore, policy 4 of the core strategy should be used for the purposes of assessing whether there is a minimum of 5 years' worth of housing against the housing requirement. Okay. Now, whilst we're looking at that paragraph, Councillor Wilson, we can see a few lines further up the observation that the factors set out in paragraph 30 above are still relevant today. Now, that's an observation that informs the conclusion to use the policy 4 figure. So let's just go back up the decision letter to paragraph 30 to see what factors taken on board by that inspector that supported his conclusion to use the policy 4 figure. So paragraph 30, reference to what MOU1 says that continuing to apply the core strategy housing requirement would, amongst other things, reflect the spatial pattern of development set out in policy 1, including directing growth to priority areas such as Cosman and North West Preston, where land allocated to deliver significant new housing in accordance with the Lancashire City deal. That's his first factor. Site allocations being determined to meet the spatial pattern of development in the core strategy. Next, core strategy requirement reflects high levels of containment for both travel to work, housing market area, and then policy 1 apportionment would help to address net out migration from Preston. A series of 4 factors there relied upon as of continuing relevance by this inspector earlier this year. What's your view about their continuing relevance now?
I still believe those factors are relevant.
Third decision letter, please. This time we move to South Ribble. And it's CD 9.3, the second of the Chainhouse Lane appeal decisions. Again, I want to start by identifying this inspector's treatment of MOU2. If we turn on in the decision letter, please, to paragraph 19. He says at paragraph 19, I acknowledge and agree with my colleagues in their respective appeal decisions relating to housing schemes at Coppull Farm and Pear Tree Lane, that any redistribution of housing requirement amongst central Lancashire authorities should not be conducted through decision-making outside of the development plan making process. It then goes on to say, however, that doesn't mean that the application of LHN, local housing need, derived from using the standard method without any subsequent redistribution cannot be considered in decision making. So to what extent was MOU2 as the basis for setting a housing requirement relied upon by this inspector?
It wasn't.
To what extent did either South Ribble or the appellant in that case, which I think was the same appellant as in the Cardwell Farm case, was it? Wayne Holmes. It was Wayne Holmes. To what extent did either of those two parties rely on MOU2 as setting?
Neither did.
Then if we turn on to paragraph 24, we can just note, can't we, that the difference between the standard method figure in South Ribble and the policy 4 figure is recorded. So 191 dwellings per annum, that should be the South Ribble as under the standard method, as opposed to 417 under policy 4. Is that right? So there was a significantly lower figure generated by the standard method as compared with policy 4, and that level of difference informed the inspector's judgment as to which to prefer. We see that at paragraph 30, don't we? If you could just turn on to that. Paragraph 30 on page 7. For the above reasons, I conclude that for the purposes of this appeal, it's appropriate to calculate the housing requirement against local housing need using the standard method, due to the significant difference between the local housing need figure and that of policy 4A, amounting to a significant change in circumstances which renders policy 4A out of date. You see that? Of course, in Chorley, as we've seen by reference to the, I think we looked at the Housing Land Supply Statement of Common Ground earlier on today, but also by reference to the Pear Tree Lane decision, we've seen that the standard method figure is higher than the policy 4 figure. I think you give us the current position in your proof, Councillor Wilson, don't you? I think if we turn up paragraph 4.47, your understanding of the current position. Page 25 of your proof. Obviously, the policy 4 requirement for Chorley is 417 dwellings a year. As matters currently stand, because the standard method figure changes from year to year depending on affordability ratios. But as matters currently stand, the standard method figure is 537. Is that correct?
Yeah.
And we can see you give us the figures for Preston and South Ribble as well, and only Chorley of those three has a higher standard method housing figure than its policy 4 requirement. Is that right? Yes. Why is that?
Well, that's based, of course, on the way that the standard method is calculated, which primarily looks at your housing delivery numbers between 2009 and 2014, which was significantly higher in Chorley.
Come back to that point in a moment or two, but I think as a general observation that will suffice for the moment. So the general observation is that the standard method figure is informed by growth in 2009 to 2014, because they obviously input into the 2014 household projections, which is the basis of the standard method calculation. We'll come to that in a moment. But just in terms of the record of delivery in Chorley, which feeds into that calculation, you go back in your proof, please. Page 18. Bottom of page 18, is the beginning of a table headed Chorley Net Housing Delivery from 2010 to 2021. So it doesn't pick up the year 2009, but it picks up the story from 2010. And we can see the first column of data is net dwellings completed. Goes over the page, obviously. And we can see it against the requirement figure of 417. And I mean, it's fluctuated, as you'd expect. It has fluctuated over that 11-year period. It appears to reach a peak in around 2014-15 when 723 dwellings are completed. Is that right?
Correct.
Do you understand there to be any dispute as to this data?
Absolutely not.
You tell us at paragraph 4.9 on page 19 that the level of oversupply in Chorley can partly be attributed to development at Buckshaw Village, which is a strategic development allocation, the former Royal Ordnance Factory. Resulted in significant development in Chorley, notable impact on overall housing completions, albeit that site is now reaching completion. Almost a third, 31% of total completions has come through. Do you mean Chorley's completion? Yes. Has come through development at Buckshaw Village. So in terms of the strong delivery of housing, including through the early years of the plan period, how important have sites such as Buckshaw Village been to Chorley's delivery effort?
That they've been at the centre of that delivery because of the scale of the developments, which of course was planned, and that's why the figures were included in the local plan for the fact that we would deliver a significant amount of housing in the first part of the plan period.
Okay. We know other bits of central Lancashire also have big, important strategic sites. So, for example, Preston, we've seen in the decision letters that we've looked at reference to these sites. Preston has northwest Preston. Has the trajectory of delivery at, for example, northwest Preston matched that at Buckshaw Village? In what way does it differ?
The significant difference was that Buckshaw was already underway, so the Buckshaw development was already underway at the start of the local plan period. Whereas in the case of northwest Preston, you're looking at green fields with no infrastructure to support any form of development. So Chorley already was underway and had a significant head start with the roads network that was in place, with the railway line that ran through the centre of Buckshaw, with the development of the railway station. So that facilitated growth that was already underway, but growth at a significant pace. Of course, Preston's not been the same, albeit now that through the City deal, that is now being able to be brought forward in their plan period. Being brought forward, as it were, later in the plan period, but still being brought forward now.
You mentioned the City deal in that answer. Just explain broadly what that is and what its purpose has been.
So the City deal is a I think it's in my proof, is a £434 million investment, a joint project between the Lancashire County Council, Lancashire Enterprise Partnership, Preston Council and South Ribble Council. Significant developments to bring homes and jobs into the City deal area. I think 334 million of that 434 is on highways projects. And that idea of the highway projects is to put the infrastructure in place to unlock pieces of land such as the northwest Preston area and allow the development to take place.
I think there's a reference in one of Mr. Saunders' proofs to a suggestion that we allege harm to the City deal. Is that part of our case?
Absolutely not.
What is the relevance of your reference to the City deal in your evidence, Councillor Wilson? How does it fit into this jigsaw?
Where it fits in is if we're looking at the three areas and the delivery of housing, it was always going to be the case that Chorley would deliver significant numbers earlier in the plan period, simply because those other strategic areas, locations, rather than site-specific. The locations weren't in at that same position, let's say, that Bookshaw was and some other sites in Chorley. And therefore, it was always going to be the case that Chorley would deliver significant numbers early in the plan period. Preston and South Ribble land would come at a later point.
Is Chorley part of the city deal arrangement?
No, it's not.
Okay, very much. And then to summarise the picture for Chorley, if you just go to your page 24, paragraph 4.44, you summarise the position for Chorley by saying that the majority of Chorley's local plan housing allocations have now been completed, with delivery having been front-loaded. It is anticipated that development levels will be lower during the last 5 years of the plan period, but the core strategy target will be exceeded overall. Does that remain your position, Councillor Wilson?
That remains the position.
And then let's just go back to this point about why the standard method figure for Chorley is relatively so high compared with that in Preston and South Ribble. If you look up a couple of paragraphs on this page to paragraph 442, you tell us that the council's view is that the standard method is not an appropriate basis for calculating 5-year housing land supply for Chorley. The standard method formula is based on household projections, 2014 based, with an adjustment for affordability. And you tell us that the standard method takes no account of any previous over or under supply. So reference to the standard method formula being based on 2014 based household projections, do you see that?
Yes.
And if we go back in your proof again, sorry to have you jumping around, 324 on page 14, you confirm your understanding of the position at 324, which is that the standard method calculation is particularly influenced by the level of development in different areas between 2009 to 2014, the core period for which the 2014 based population projections were derived. You see that?
Yes.
And then in terms of the facts here, over this period, 60% of the housing market areas completions, so that's central Lancashire areas completions, were in Chorley, with just 16% in Preston. That obviously feeds into the analysis that generates the standard method figures that we've seen. So just in broad terms, how substantial was the delivery of housing, would you say, in Chorley in that key period, 2009 to 2014, as compared with the level of delivery in Preston and indeed South Ribble?
Significantly substantial. We compare the numbers, it's totally different, a completely different picture in Chorley than it is in Preston and South Ribble in terms of delivery. We were accelerating year on year, as the figures show, and that wasn't matching our neighbouring authority areas.
Thank you very much. Right. Let's go back to the Chain House Lane decision letter, please, and that was CD 9.3. So this is the decision in South Ribble, which preferred the standard method approach. And if you could find, please, Councillor Wilson, page 4 and paragraph 18. The inspector there says that the use of the standard method in producing the emerging local plan would be consistent with paragraph 60, and that equivalent paragraph is now 61 of the current revision of the National Planning Policy Framework. You see that?
Yes.
which states, amongst other things, that to determine the minimum number of homes needed, strategic policies should be informed by a local housing need assessment conducted using the standard method in national planning guidance. And that's precisely what now paragraph 61 says. We needn't turn it up, there's no dispute as to it. So for plan making purposes, national policy says start with the standard method figure. So the inspector then goes on to say, I therefore also consider that the direction of travel is towards use of the standard method. Do you see that?
Yes.
Now, one of the documents supporting the emerging local plan, which, as we've noted, is at issues and options document stage, is a 2020 housing study. Let's turn that up, as I think I mentioned we'd come to. CD 6.21. Commissioned by the three Central Lancashire authorities, produced by a firm called Iceni, and dated March 2020. Yeah, we got that. And you refer to this document in your proof of evidence, Councillor Wilson. I think at there was a page we were looking at paragraph 322, you mentioned the Central Lancashire Housing Study. We can just identify what it does briefly. I don't want to go through a lot of this in detail, but having reviewed the policy, national policy position, it then has a section number 3, which starts on page 9, headed overall housing need. Have you got that?
I have.
And it proceeds to set out what was then the standard method figures for each of the 3 Central Lancashire authority areas. And we can identify those on page 10. As they then stood, obviously affordability factor has changed since then, but as they then stood, the figures, the local housing need recorded in table 3.2, including the figure of 579 for Chorley, yes, and lower figures in turn for Preston. And just then noting, I don't want to go through the rest of section 3 in any detail, noting what is done at section 4 of this document, headed the distribution of housing need. You see that?
Yes.
By reference to a whole series of different factors, for example, table 4.2, page 20, where the workforce are, table 4.3 on the same page, where the jobs are, table 4.4 on the next page, the affordability ratio, a whole series of factors gone through, a distribution of those local housing need figures is recommended. Is that right?
Yes.
Again, all of this is in your proof of evidence, and I don't want to take it, I want to take it as swiftly as I can. We get to the summary of that analysis on page 32 in this document, if you could turn on to that, table 4.14. And so you've got those various factors: jobs, population, affordability, affordable housing need, so on. And the way in which those factors are distributed across the 3 local planning authority areas by reference to percentage figures. Do you see that?
Yes.
That compares with the distribution of local housing need by reference to the, if you like, the solar standard method figures, which are then set out on the next page at table 4.15. Yeah. So for Chorley, 57%, Preston, 23%, South Ribble Borough Council, 20%. And having referred to all of those various factors, such as jobs, population, and so on, it recommends a distribution of housing across the 3 central Lancashire authority areas set out in table 4.15, 27.5% for Chorley, Preston 40%, South Ribble 32.5%. So let's just be clear about this direction of travel point. Obviously, the emerging plan is at an early stage and can carry only limited weight. But in terms of the observation that the direction of travel is towards use of the standard method figure, which of course it is for the emerging plan, because that's what national policy tells us to do. What's the likely destination, having got on that journey towards use of the standard method figure in the emerging plan? Is it likely to be the SOLAS standard method figures applied to each of those authority areas, or is it likely to be something else?
No, I mean, it's not. It won't be the sole standard method. It will be a redistribution. That's indicated clearly in the study and is part of our thinking as a council and is shared across the 3.
Okay. Now, thank you. We can probably put that 2020 study, close that down, put it to one side. Next point, though, is a statement in document MOU2, which is to the effect that the policy 4 figures are out of date, and that's relied on in part by the appellant as supporting their position. And let's just identify for the inspector's note where that appears. So if you could find CD 6.30, further memorandum of understanding, what I'm calling MOU2, and I think what's generally referred to as MOU2, dated April 2020. There are 2 documents, Mr. Cannock. They're different documents. 6.30 for the time being. This is where the statement that I've referred to appears at paragraph 2.4 of that document, Mr. Wilson. Yeah. Which states that the councils consider that maintaining the use of the housing requirements set out in policy 4, which is now out of date till such a time as the review of the local plan is complete, is not appropriate and has been superseded by the standard housing methodology as explained below. And as I say, some reliance is placed upon that. The document then goes on to refer to the 2017 MOU, MOU1. I won't go through this in any particular detail. Section 4 deals with changes to the national planning policy context, which are recorded as being significant and of course include the revisions to the framework and accompanying planning practice guidance introducing the standard method approach to calculating local housing need. Section 4. And then calculations set out at section 5 with regard to the standard method figures of application at that time. See that? Of course, it doesn't stop there because it then seeks a redistribution of those standard method figures in section 6, relying in part on the 2020 housing study. And in fact, we can see, I'll give you a page number, but under paragraph 6.9, table 1, the same recommended distribution as per the 2020 housing study. then that's taken into sections 7 and 8, setting out what it's considered to be the housing requirement applying to each of the authority areas by reference to that redistribution of standard method housing need. Do you see that? Now, we've looked at the 3 appeal decisions in central Lancashire since MOU 2 was produced. Pear Tree Lane, Coppull Farm, Chain House Lane. We've seen that none of them endorse MOU 2. We've also seen that none of the parties in Cardwell Farm or Chain House Lane following the Pear Tree Lane decision sought to rely on MOU 2 in any context relating to housing, land supply in central Lancashire that you're aware of. Has anyone sought to place reliance post Pear Tree Lane on MOU 2?
No.
And just, I'm not sure we need to turn it up because I know you're familiar with these appeal decisions now, but just in respect of the 2 decision letters that followed Pear Tree Lane, so Cardwell Farm and Preston First, where obviously the policy 4 figures were preferred. To what extent did that inspector consider the statement at paragraph 2.4 of this document, which is that the councils consider that the use of the housing requirements in policy 4 is out of date? To what extent did the inspector give any weight to that statement as far as you're aware?
No weight was given.
Similarly, in respect of Chain House Lane decision, where the inspector went in the other direction and preferred the standard method figure, to what extent did that inspector's reasoning rely on MOU 2 and the statement at paragraph 2.4 that we've looked at?
Again, it didn't.
All right. Now, as we've seen, application of the standard method calculated local housing need figure in Chorley gives a higher result than policy 4, and in Preston and South Ribble gives a lower result than policy 4, and you've explained why you think that is, based on the 2009 to 2014 record of delivery fed into the 2014 projection. In the event that the standard method figure for Chorley is applied, then the result, there's no dispute as to this between you and the appellant, as I understand it, Councillor Wilson. The result is that we won't be able to demonstrate 5 years' worth of housing land supply.
Correct.
And therefore the tilted balance will be engaged. What do you say the risk for the continued protection of safeguarded land is in that event?
The issue there, if we couldn't demonstrate the 5-year supply, simply would be that obviously the safeguarded land as it stands would then be under threat and inevitably be brought forward for developments. And then that has a knock-on effect, obviously, on the Greenbelt land.
Assuming safeguarded land has been granted planning permission during the currency of the plan period, and so come the next review, if you like, the reservoir of safeguarded land is diminished, is it right to say there is no planning harm in the event of that outcome, as I think the appellants possibly say? And if it's not right, what is the possible planning harm?
Well, the possible planning harm is obvious, that without the safeguarded land to be used for the next plan period, one is then considered to look at greater swathes of Greenbelt land that would need to be brought forward for the following plan review.
What the appellants say here, might say here, is that, well, that doesn't matter because you're going to have to meet a housing requirement in your emerging local plan. This site has been identified as a potential candidate thus far in the emerging local plan, and therefore, just a question of timing. I think that was said earlier on. Therefore, there's no tangible harm that arises. Is that your view of the
that's
potential
not
harm?
quite the case. I mean, there is a logic, of course, which is land could be developed on at some point, but that's not our view, because our view is if the land currently safeguarded land is available to be considered in the next plan period, obviously that would have to be taken into account. That therefore influences potentially how much other land is needed to be brought forward, in particular greenbelt land. So it's not just a question of timing, it is a question of scale and impact on future greenbelt release. Secondly, of course, those sites would have to be reviewed again for suitability, as would other sites. And again, that work's not been done yet.
Do we know what Chorley's housing requirement is going to be in the next adopted plan? No. Do we know how much additional greenbelt is going to have to be released in order to meet that requirement?
Absolutely not.
And just looking at the other aspect of that argument, the potential pressure that Chorley is under in the meantime, pending that local plan review. What's your experience been of proposals to develop on safeguarded land since the Pear Tree Lane decision?
Well, fortunately, since that decision, we've received a significant number of applications. All of which have been refused, some of which have been appealed.
I think you list the applications.
We do list the applications.
But I don't ask them to turn that up. In several. To what extent does that same level of risk arise in Preston and South Ribble as a result of the application of the standard method figure as opposed to the policy 4 figure?
Well, obviously, it doesn't arise in their position for a number of factors. One is the numbers went down, as you say, under the standard method, their numbers go down. Secondly, they do have sites that have already been identified in this period to be brought forward that they can still rely on. And thirdly, of course, they don't have the significant constraints of a large amount of greenbelt land. As I say in my proof, I think 72% of our land is greenbelt, and therefore that is not the same in South Ribble or Preston. So the impact wouldn't be the same, even if they were asked to deliver a lot more.
Bear with me, so there's one other point I wanted to take you to on that issue before we move to oversupply. Oh yeah, it was just to note the figures with regard to constraints in each of the 3 local authority areas with which we're concerned. I don't know if you've still got MOU2 open. Remember, we briefly touched upon Table 1 under paragraph 6.9, which effectively sets out the same series of factors, at least some of them looked at in the 2020 housing study. And I note on that table, this is as per the 2020 study, land not subject to national constraints. Not subject to national constraints, so it's the relatively unconstrained. And I think, needn't go back to the 2020 study, but national constraints include greenbelt. It includes lots of other things as well, like ecological, nationally important ecological sites and so on. And one sees there a series of percentages set out. Chorley, not subject to national constraints, 20%. That compares with 86% of Preston, not subject to such constraints, and 33% in South Ribble. All right. Let's turn to the second of the 2 main issues in respect of the degree of housing requirement. Having dealt with policy 4 versus standard method, I want to now turn to what you do with what I'm at least going to call oversupply. Now, I think you refer fairly in your proof, as does Mr. Saunders, to a series of appeal decisions in which inspectors have reached different views as to whether or not you offset previous year's oversupply against your 5-year requirement, or you don't. And the paragraph 481, and I don't want to go through each and every one of those, I'm not sure I want to go through any of them just now, but paragraph 481, you summarise it in these terms. There are evidently appeal decisions which support both approaches. I consider that there are specific local circumstances which mean that taking account of past surplus is appropriate for Chorley. Yep, you see that?
Yes.
So as I understand our position through your evidence, Councillor Wilson, you say that whether or not you offset oversupply is a question of judgment.
Correct.
Okay. Do you understand Mr. Saunders to take any different approach as to whether or not it's a question of judgment?
No.
And then at 481, you tell us what you consider to be the factors of application to Chorley which support an approach whereby oversupply is offset. Yes. And you tell us that that's the nature of the housing requirement, the way this has been planned to be delivered between the authorities across the joint core strategy area, and also the significant greenbelt constraints. So 2 issues that we've already looked at, albeit in the context of policy 4 versus standard method. But just so we're clear, when you say the way the housing requirement has been planned to be delivered between the authorities, what do you mean by that?
Again, going back to the point of the core strategy numbers and local plan, which predicted that Chorley would have significant delivery in the early part of its plan, the first 10 years, as has been delivered, as proven, and the fact that those sites in other areas will come on stream later in the process.
Okay. And then the second factor is the degree of greenbelt constraint in particular. I think you've already referred to that and how it affects Chorley in particular as compared with Preston and to a lesser degree South Ribble. All right. I don't think I need ask you anything more about the oversupply issue and how that's treated. We can take your evidence as read in that regard, including your review of the various appeal decisions. Madam, I just note there that in case you didn't have enough appeal decisions, there was a late addition, and it was another Tewkesbury case called Willowbank Road at Alderton. It's not covered in Councillor Wilson's proof because I think it postdates its preparation, but it's CD 9.28. And just for your note, the inspector, although the inspector allowed the appeal, the inspector supported Tewkesbury's approach, which was to offset oversupply against the housing requirement. So she didn't agree with everything I put to her in that bit. Just most of it. No, you didn't. They are in. Yeah, so glad you've got firm control over your team, Mr. Cannon. Right. Last point, please. I think there is a continued proposition in Mr. Saunders' evidence, I don't ask you to turn any of these references up, to the suggestion that if you adopt our approach, you will fail to achieve central government's objective of significantly boosting the supply of land for housing. Do you recall seeing that?
Yes.
Repeated.
Many times.
Your case, we've seen the reference in your proof, is that as matters stand, Chorley will exceed its planned policy requirement for housing for the planned period.
It will.
I needn't ask you to go through the figures. We can descend to that detail if needs be later in the inquiry. But your case is planned period requirement will be exceeded in Chorley. It runs until 2026. So we know what it's likely to be because we've got the 5-year assessment that takes us up to 2026.
Yes.
If we do that, if we materially exceed the planned period requirement for Chorley, to what extent will we have achieved the national policy objective of significantly boosting the supply of land for housing?
We would have achieved it. We would have achieved it by meeting the numbers in the plan as when reviewed, because that was national government policy at the time. And that's what that plan achieved. With the fact that we've gone beyond means that we've even even further achieved in line with the government policy.
All right. There are other disputes between you and Mr. Saunders, including the degree to which benefits, which are not in dispute, attract weight.
Yes.
So, for example, I take this by way of example, you attach significant weight to the provision of affordable housing. The appellant attaches very significant weight to the provision of affordable housing. In your view, in your exercise of the planning balance, does that difference affect the outcome? So were you to have plugged in very significant weight to the provision of affordable housing, would your answer be any different?
No.
All right, thank you very much indeed, Councillor Wilson. Thank you, Madam.
Okay, thank you, Mr. Conser. Right, then I'll turn to Mr. Cannock. Do you want to start your cross-examination of the witness, please?
Councillor, if I don't spend every moment looking
I appreciate
directly
it.
at me, I mean no discourtesy. Councillor, I want to look briefly at your qualifications and experience with reference to your 1.1. You claim no professional qualifications in planning or any other land use planning impacts such as highways or ecology, do you?
No.
And you don't claim any relevant professional experience either, do you?
Nope.
So the only lay experience you claim is as a councillor for 13 years and as deputy leader. For how long have you been deputy leader?
9 years, or just over 9 years.
9 years. And have you served on the planning committee?
Nope.
Right, so that's the totality, I think, of your experience for the purposes of this inquiry, together with what you told Mr. Punter about your experience with Mr. Manley and Redred. Right. And if I look, please, at your 441, and I may come back to this later, but it's more of a housekeeping exercise at this stage. We're told that the council, and obviously you understand that the council is a creature of statute and it has a scheme of delegation. And you tell us the council has considered the latest Chain House Lane decision carefully. And it was my recollection that Mr. Ponter told the case management conference of that intention. How has the council considered its position?
Consider its position in detailed discussions with senior officers and leadership and relevant executive members.
So how and when was any decision taken?
In relation to the Chain House Lane decision.
Yeah, you're talking about the council, and if you want to mean you, okay, you might want to change it, but I'm thinking about the council as a corporate body, has considered the Chain House Lane decision. And obviously, you've decided in the light of that decision to continue to oppose this appeal. So
Yes.
I'd like to know from you how the council has reconsidered its position and how and when any decision was taken.
But if you made a decision through the full council, for example, that's not gone to full council. That's within the purview of the leadership and the executive member to form an opinion on the advice of officers. Our opinion is as stated in my proof of evidence,
Right.
and that is the council's position.
Are there any relevant reports or resolutions that I can examine to see any transparent reasoning as to how, not the council, but you as part of the leadership team have reached that decision?
I don't think there'll be any published reports, but we are consistent with our previous statements. And the issue has been, I could try and find the date for you, Mr. Cannock, but at the top of my head, you'll appreciate I don't have that, where this has been discussed at full council, and it's been made very, very clear the policy of this council in relation to housing developments and the 5-year land supply issue. Has that been a formal vote, if what you're asking for? No, but the issue has been discussed. It's been made very, very clear.
No, I think I'm really looking for a report where I can see what the pros and cons were as to what the basis of the analysis was. And I think you're telling me there's nothing transparent.
No, there'll be no such report as that, apart from our previous statements made in previous planning inquiries, some of which are referenced here. Obviously, the most recent one at Town Lane and Tinkers Lane. Council's position is very consistent.
Right. Now, you've clearly had support from professional officers in the preparation of this proof of evidence, haven't you?
Correct.
And you've had the advantage of advice and input from Adele Hayes as head of planning and Melissa Kurahara, haven't you?
I have.
By virtue of the fact that you as a local councillor, I don't mean that disrespectfully at all, but the fact that you're here to give evidence presumably reflects the fact that the resolved position of Chorley can't be supported by professional officers. Is that right?
Our position is obviously the position set out. Officers may have an issue with some of those in their professional judgment. They may form a different opinion, but our opinion is what it is.
Right, understood. Right, I'd like to just look at some points of common ground, please. There's no issue between us regarding the detail of the access, is there?
No.
And you, of course, as a councillor and a deputy leader, have listened carefully to the concerns of local residents in reaching this resolved position. And I want to then concentrate on the significant measure of common ground on the principle of the development of this site. I want to look at safeguarded land, please. Your proof of evidence at 3.9. It should all be common ground. We'll just note the chronology. And if you get lost, it's because sometimes your paragraph references goes awry. So perhaps I'll give you the page number as well. It's 3.9 on page 12.
Yes.
So the Lancashire Structure Plan 86/96 set out the extent of the greenbelt, didn't it? Mm-hmm. And then there was no change in the Lancashire Structure Plan 1991 to 2006, was there?
Nope.
And then you had the Chorley Local Plan, which sought to implement the Lancashire Structure Plan of 91 to 2006, correct?
Yep.
And it was in the 1997 Chorley Local Plan that the appeal site was removed from the greenbelt and designated as safeguarded land, wasn't it?
Yes.
And at your 3.2, you refer to PPG 2, which was in force at the time of the adoption of the Chorley Local Plan in 1997.
Yes.
And if you turn, please, to Mr. Saunders' planning proof, Appendix NJL5, please.
You have the reference to that, sorry.
I've made
bring it up on my screen, sorry. I do apologise.
No, please don't apologise. I've made the mistake of thinking people would have the proofs in hard copy. You got the reference for the proofs? Well, I hope this isn't the first technical problem, but I don't think the proofs are core documents. Did you have hard copy?
They're all on the website.
Oh, well, they just separately listed? I don't have them as core documents on my list.
The
Do you have,
old-fashioned way.
well, I do the old-fashioned way. Thank you very much. Use a wipe if you feel sensitive about it. Yeah, so if you could find NJL Appendix 5, please, PPG 2 on green belts. And we know this was published in January 1995. And if you could find within it the paragraph from which you quote partially, 2.12. Yeah, have you got it?
At the bottom, 2.
Yes, please.
Yeah.
And what this is telling us in 1995 is that it applied when reviewing local plans, didn't it?
Sorry, yes.
And we're told then that local plans should be related to a longer than normal timescale when related to green belts, aren't we? And the aim was that the green belt boundary should not be altered at the end of that plan period. So in 1997, it shouldn't be altered at the end of the plan period in 2006, correct?
Yeah.
And the purpose then of safeguarded land was to ensure the protection of green belt within that longer timescale, wasn't it?
Yeah.
And if we look over the page, please, third line down, plans should consider the broad location of anticipated development needs beyond the plan period, its effects on the urban area and beyond, and its implications for sustainable development, correct? And then we're referred to Annex 2, to which you also refer. If you turn to Annex 2, that's Appendix 6. We see that it's in 2 parts, isn't it?
Yes.
So we've got firstly identifying safeguarded land and secondly development control principles, correct?
Yes.
And you refer to the second part at your 3.4, but you don't make reference in your proof of evidence to the first part, do you?
No, not there.
If we just look at it, B2, what it's telling us is that safeguarded land may be required to serve development needs well beyond the plan period, which in 1997 was 1991 to 2006, correct?
Yes.
And we're told that it should have been genuinely capable of development when needed, correct?
Yes.
And it follows then that in 1997, this authority was satisfied that the appeal site was genuinely capable of development when needed, wasn't it?
Yes.
And if I look at B3, the local authority was also satisfied that future development on the appeal site would be an efficient use of land, correct?
In line with that, yes.
And it was also well integrated with existing development and well related to public transport and other existing and planned infrastructure. Yeah?
Yeah.
And the local authority was satisfied that development on the appeal site would be sustainable development when needed, correct? And if I look then at B4, that conclusion was reached in the light of extant national policy on housing and transport, which provided policy on sustainable locations for housing development, correct? And on this point, or on those points, the authority's position has never changed, has it?
No, not on that principle, no.
No. Because what you tell us at your 311 is that the local plan was reviewed in 2003, wasn't it?
It was.
And it was again allocated or designated as a safeguarded site, wasn't it? And the appeal site was again identified as a suitable location for housing development when needed, correct? And if I look at your 3.12, please, I don't want to be too picky about it, but just to try and get some of the chronology straight, I think 2010 was the date into the first EIP of the Joint Core Strategy, because 2012 was the start of the plan period. And the Chorley local plan was adopted in July 2015, wasn't it? Yeah. And again, then on the 21st of July 2015, the site was again identified as safeguarded land, wasn't it?
Yes.
And just in terms of the Chorley local plan, of course, a large amount of safeguarded land was allocated for housing development at that time, wasn't it?
Yes.
And the residue was identified as safeguarded land under policy BNE 3, wasn't it? And so, I mean, it follows, if you take a step back, that this authority has accepted over a 25-year period that development of this site for housing would constitute sustainable development when needed, wouldn't it?
No, the logic has followed it down as safeguarded land, yes, which in that definition means it could be used for development in the future.
Yeah. And if I look then back to Annex B of PPG2, if you could just go back to the second development control policies, I want to try and identify essentially 3 restrictions. The first is what I call a temporal restriction, because it talks about it's not allocated for development at the present time. So that's a timing or a temporal restriction.
Correct.
The next restriction concerns prejudice later comprehensive development, doesn't it?
Sorry, where are you now?
Yeah, sorry. So B5.
B5, yes.
4th line, no development which would
yes.
prejudice later comprehensive development.
Yes.
And of course, nicely, we can ignore that because that was a reason for refusal, which has now been addressed. So there's no issue about comprehensive development, is there? And then the third restriction is essentially procedural because it refers at B6 to following a local plan or UDP review, doesn't it?
It does.
And so what we can agree then is that the principle of development on the appeal site is considered to be acceptable subject to timing and process, correct?
Subject, yes, those are the issues at play. Yeah.
Right. And whilst you make reference to changes in policy, and if it helps you, it's your 3.5 and 3.6, to changes in NPPF 2012 and 2021, I don't think that you identify any relevant or material change in national policy from PPG 2 through NPPF 2012 through to NPPF 21, do you?
Policies there are relatively consistent, but that is our point, isn't it? That it remains safeguarded land for the long term to meet development needs beyond the plan period. That policy hasn't changed, which supports council's position.
Your point, there's been consistency of approach at the national policy level.
Right.
So then, in terms of our agreement, please, if we could pick up next the statement of common ground on planning. Yes, yeah.
It's not got CD numbers, and it's on the website. It follows the list of proofs of evidence. There's a heading statement of common ground personal planning.
Don't start, sorry. There we are. Thank you.
And if I just invite you to look at
Are you around which one do you want me to
statement of common ground on planning, please.
Planning statements of common ground.
And 4.5, we have the site represents a sustainable location for new housing development. That's agreed, isn't it? Sorry, page 11, 4.5.
Yes. Yes.
So we agree it's a sustainable location for new houses. And at 4.6, there's no technical constraints at all to housing development now, are there?
No, not that I'm aware, no.
Right.
No.
And so we come back to the point that the principle of the development is acceptable on your case, subject to, firstly, any harm as a result of the timing of the development, and secondly, any harm to the plan-led system.
Yes.
Right. And that, of course, has to be consistent with the local authority's resolved position that this site should be allocated in the next plan. It's consistent, isn't it, with your acceptance of the principle of development subject to timing and process.
Subject to the process taking place, it may be included in the plan, because that's the whole purpose of the plan, isn't it, that you review all your sites.
Yeah. And if we just think about this, of course, the site is proposed to be allocated in the issues and options emerging local plan document, isn't it? Yes. And if you just look still within the Statement of Common Ground on page 8, at 3.8, it's agreed between us that the emerging local plan will cover the plan period of 2021 to 2036. Correct? Right. So we are already in the next plan period, aren't we?
When it's adopted. Yeah. But that work's not been undertaken yet, so.
Very helpful, thank you. I just want to identify then the aspects of planning harm that you identify, please. If you turn to your proof of evidence at 3.1, and I think that this is a rogue 3.1, so I'll try and give you, yes, so it's on page 10.
Yes.
So at 3.1, you have a concern about increased pressure on the Greenbelt through the emerging local plan process, don't you?
Yes.
And next, you are concerned about harm to the plan-led process. You set that out at the end of 3.1, aren't you?
Yes.
And those same points are repeated if you turn on in your proof of evidence to 333 on page 16.
Yes.
At 333, you're concerned about undermining of the plan-led system. And at 335, you're concerned about essentially release now, increasing the likelihood of Greenbelt release, yes. Correct? Right. And those are the land use planning impacts which you identify, correct? Nothing else?
Nothing else, sorry, just repeat that.
There's no other land use planning impacts that you identify, adverse land use planning impacts?
No, not on those, no.
Right, thank you. Now, just on timing, please, we accept a temporal restriction on development in the Greenbelt, but I want to test how significant it is, if at all, as between us. Firstly, the extant plan period is 2012 to 2026, isn't it?
Yes.
And so the local plan expires in March 2026, doesn't it?
Yes.
And there needs to be continuity in the plan-led process, doesn't there? Of course. And so surely need a plan in place before 2026, don't they?
We do.
In fact, you need a plan a couple of years in advance of 2026 so that in the light of allocations, people can make applications so that there's delivery early in phase 1 of the next plan process. Thank you. Could you turn, please, to CD 6.6, please?
That is the Central Land Use Development Scheme.
LDS, Mum, correct. I'm better on the actual core documents. I'm afraid I haven't given you references for the Statement of Common Ground and the proofs. That's my failing. So CD 6.6, and if you could find, please, we see it's the LDS January 2020 to January 2023. And if you can find, please, the heading Programme, and that's on page 7 of 8. And if we just look at the latest resolved LDS of this local authority, we see the LPA is aiming for adoption in November, December 2023, isn't it?
Yes.
And it would follow then that the allocations could then deliver from 2026 onwards, couldn't they?
Yes.
And so just to be clear then, in terms of the current resolved positions of this local authority, it's firstly that this site should be allocated in the issues and options paper, correct?
Yes.
And that it will be allocated by November, December 2023 to contribute in the next plan period.
Following the logic of the net, that it's still included as you work through the plan period, as you work through the development of the plan. We're only at a very early stage, as you are aware, in the issues and options. In theory, that could change.
Well, I understand that things may change, but I'm just trying to look at the decisions that this council has taken that I can examine. Resolved to support the allocation in the issues and options paper, correct?
Yes.
Resolved to have a plan adopted by November, December 2023, correct? And it follows then that it's resolved in the issues and options paper that this site could contribute in the next plan period, 2021 to 2036.
Yes, with the emphasis on the word could.
And on the basis of those resolutions, all of that would be acceptable to this local authority, wouldn't it?
It would.
Yeah. And I just want to see then the difference between us, because in contrast, this appellant is seeking an outline planning permission, isn't it?
It is.
And both the allocation and the outline determine the principle of development, don't they?
Yes.
And so if this appeal is successful, consent may be granted in, let's say, Q1 2022.
If the appeal is successful, absolutely.
Yeah. And so the issue of timing is a difference between an outline consent Q1 2022 and allocation Q4 2023, isn't it?
That's that. I mean, in theory, that fits, but the big difference, sorry, just, I might be digressing perhaps onto your next point, so I apologise, but the big difference being that if that was allocated, so I'll put the word emphasis on the word if it was allocated in the plan, that would be done after the consultation, after the public consultations, therefore residents in the area, as well as other areas, would be aware, they would have the ability to contribute to that plan, it would be debated and decided on in this council. At the moment, yes, you might say the difference is only a couple of years, but that would be taking place without that consultation, without that plan-led process. And as I say in my evidence, with the impact on the Greenbelt not being considered through the plan process as well. So I accept the issue of timing. In theory, could be, you could be absolutely right, it may not come forward that quickly, who knows? In theory, that could be the difference. But the big difference is that one is done in a piecemeal fashion, i.e. subsequent appeal here without any greater consideration to the issues that are facing this authority in the area, i.e. the impact on greenbelts, and the issue of if you are changing the designation of land from safeguarded to being brought forward for development, that should be done through a plan-led process. We would have bypassed that important part of the process.
I'm going to come in detail on harm to the plan-led process. I'm on timing at the moment.
Yeah, no, I appreciate it.
I just want to pick up the point about consultation. Of course, there's been consultation on the planning application and on this appeal.
Just on this single appeal, but that's not our fundamental issue, as you're aware. My evidence is it's the knock-on effect across the board and throughout the borough.
Well, I will deal with that. But just on this issue of timing then, it's a difference we've agreed between an outline consent Q1 2022 and allocation in Q4 2023, isn't it?
In theory, that timing is possible.
Yes. And of course, you've seen the trajectory set out by Mr. Saunders for delivery on this site, haven't you?
Yes.
I don't think you take any issue with it, do you?
No, again, that programme could work.
And so if we were to have an outline consent in Q1 2022, you're unlikely to have completions prior to Q4 2023, are you?
No.
Right. It's fair to say then that this issue of timing, as I said in opening, is vanishingly small, isn't it?
I won't call it vanishingly small. It is obviously not. It's reducing, isn't it, as each day goes by?
Yeah.
And as you say, the actual building out of the building out of the site will still take the same time, whether it's whenever it's done, whether that's 2022, 23, 2029 or 2030, that doesn't change. So the issue we're dealing with isn't, in my view, again, and I'll go back over what I said, it's not the issue of we're arguing over those 3 or 4 years, we're arguing about the broader impacts and the broader policies surrounding the need to protect safeguarded land, and if changing that designation, that it's done through a plan-led process.
Yeah. You don't provide anywhere any evidence that this issue of timing is material, do you?
No.
I'd like to ask you next a long suite of questions about the evolution of the development plan, and in the light of that, I'm going to pick up the points about the points that you've just raised about harm to the plan-led process and impact to the green belt. I'm mindful that the councillor has been sitting here for a reasonable period of time. I think, in fairness to him, to try and maintain the thread of the next suite of questions now might be an appropriate time if you're content.
Oh, that's helpful, Mr. Connect. I was just going to suggest this, actually. You read my mind when you just said it's going to be a long suite of questions. I was just thinking, yes, Mr. Councillor Wilson's had an hour and a half already. So, yes, so if we have a short break then, it's now about 20 past. If we return at 3:35, 25 to 4, that'll be fine, thank you.
That's much better. Thank you. Are we better now? Right.
Right, thank you very much, everybody, for returning on time. So it's now 3:35 and we will continue with Mr Cannock and his cross-examination of Councillor Wilson.
Thank you, Ma'am. Evolution of the development plan, Councillor, you deal with this issue from 3.8 onwards. I want to address with you a number of highly material points that aren't addressed in your evidence, please. Could you pick up, please, Mr Saunders' housing land supply proof at page 20?
Page 20.
Yes, please.
Yeah.
And he sets out there a heading housing need and requirement figures in central Lancashire. And in terms of the background evidence, I don't think you have any apparent criticism of his evidence or analysis, do you? Certainly not provided any contrary analysis.
No.
So I'd like to just go through this with a light touch, but I can't ask my subsequent questions without having done a certain amount of preparatory legwork. Ma'am, just for your note, can I invite you to look at CD 633, which is the proof of evidence of Mr Ireland for South Ribble at the second Chainhouse Lane decision. Section 5, Ma'am, sets out his derivation of the housing requirement in SRBC, and at 538 you have an analysis of the housing need and requirement and figures in central Lancashire. Ma'am, I'm not going to go through that. It's just for your note, you'll see that there is consistency between what we say and what, for example, a local authority in SRBC have to say. So, as lightly as we can then, Councillor, RSS first of all, Mr Saunders at 5.4 on page 16, it's right to say that RSS was derived using the methodology in PPS3 for housing, wasn't it? And housing need was then derived at the regional level and then manually redistributed based on the spatial strategy, wasn't it? Yes. And if I look at 523, please, of Mr Saunders, the RS was based on 2003 household projections, wasn't it?
Yes, it was, yeah.
And we know at 523 that the 2003 household projections were based on evidence from the preceding 5-year period, 1998 to 2003, correct?
Correct.
And you would accept that demographic evidence from 1998 to 2003 is very significantly out of date, wouldn't you?
It is, but of course that has been reviewed subsequently.
Yeah, I'll come on to the review in due course. But just as a piece of evidence, demographic projections 1998 to 2003 can be considered to be very significantly out of date, can't they?
They will be out of date, yeah.
And what we know is that the RS had a planned period of 2003 to 2021, didn't it?
It did.
And it didn't provide any evidence at all about housing need from 2021 onwards, did it?
Not that I'm aware, no.
And if I look then, please, at Mr Saunders' table 4, page 21, I see the 2003 household projections, and I see that for Chorley, it was 573 dwellings per annum, don't I?
That's correct.
And what happens is the 573 was reduced to 417 in the final RS, wasn't it?
It was.
And for Preston, 401 was increased to 507, and 458 was increased to, 458 was reduced to 417 in South Ribble, correct? Yes. And so what we see is a manual redistribution of housing need away from Chorley and South Ribble to Preston, correct?
Correct.
Because Preston was considered to be the sub-regional pole, correct?
Yeah.
But on the basis of the 2003 based household projection, the greatest level of housing need was in Chorley by a significant margin, wasn't it?
Yes, on those figures, yes.
Turning next then, please, to the joint core strategy, could you turn, please, to CD 619? So CD 619, and this should be the inspector's report. Yep. And if you look on the first page of the EIP inspector's report, I just want to reflect on the chronology. Do you see documents submitted for examination on the 31st of March 2011? So on the bottom of the cover sheet.
All right, fantastic. Yes.
So submission, 31st of March 2011, and then hearings, June, July 2011, correct?
Yep.
And at that point, the HMA authorities were proposing an 80% of RS figure, weren't
An 80%.
they? I can take you
take me
to,
there, yeah.
If you look at paragraph 47,
Yes.
policy 4 at that time was setting an 80% of an RS figure, wasn't it?
Yes.
So it wasn't trying to significantly boost the supply at all. It was trying to constrain it. And what happens is that was revised to 100% of the RS figure, wasn't it?
Again, if you.
Yeah.
I think that's right, but I'm just
Yeah.
checking.
Well, you're quite right. You be as cautious as you like. Turn to paragraph 10, please. If you just look at paragraph 10 and then the first two lines of paragraph 11. And so what happened is the joint core strategy was submitted in March 2011, first DIP June, July 2011 at 80% of RS. The inspector in his interim views in paragraph 10, his letters of the 15th and 27th of July said, that's not acceptable. You need to adopt 100% of the RS figure. And then it went back for a second examination on the 6th of March 2012 and found 7. Yeah. And what one can see if you look on page 2 of the document, MM1, the main modification was simply the adoption of the RS annual average housing requirement, wasn't it? And so what is happening is the joint core strategy is simply rolling forward the RS housing requirement, isn't it?
In effect.
Yeah. Turn next, please, to CD 6.2. And this is, so CD 6.2, this is the Chorley Local Plan 2012 to 2026, isn't it?
Yes.
And so the joint core strategy was the Part 1 plan. This is the Part 2 plan, correct?
Yeah.
And it was adopted, we know from the front page, July 2015, correct?
Yes.
And if I invite you to find, please, 5.9 on page 20 of 98. It's internal page 16, actually, on the document itself.
Yes.
What the Chorley Local Plan is doing is simply rolling forward without further analysis the housing requirement in the RS and the joint core strategy, isn't it?
Yes.
And so we can be clear, the local plan is planning to the housing requirement of the RS core strategy, correct?
Yeah, which was found sound by the inspector.
Well, I don't think the inspector was looking at the housing requirement because it had been fixed by the joint core strategy.
That's right. Yeah, so it's a perfectly legitimate to adopt that sort of thing.
Absolutely. There's no requirement. We know the legal principles for it to be revisited. But we can agree unequivocally that the Chorley Local Plan was adopted solely on the basis of the regional spatial strategy, joint core strategy housing requirements, wasn't it?
Yes.
And if one just turns on in the document to policy HS1, please. So that's on internal page 20. The purpose of the housing allocations then is to meet the housing requirements set out in the RSS Joint Core Strategy housing requirements, wasn't it? Yeah. And in terms of safeguarded land, it was in the context of those housing requirements that surely considered safeguarded land, correct?
Of course.
And you tell us at your 3.12, please, if you turn to that. And I think it's on page 7. What we know is there was a process by which some safeguarded land sites were allocated, correct?
Mm-hmm. Yes.
And you tell us that the most sustainable were allocated and the remainder, including the appeal site, retained the designation of safeguarded land to meet the need for housing after the Joint Core Strategy period.
That's right.
Yeah. And now, in the latest version of the Emerging Local Plan, I think all of the remaining safeguarded land is proposed for allocation, isn't it?
In the issues and
Yes.
as far as I'm aware, yes.
Right. And in that context, then, the local plan proposed a series of boundaries. And I just want to agree with you the areas then that this local plan has. Firstly, we have urban areas surrounded by settlement boundaries, don't we? Secondly, we have safeguarded land addressed by policy BNE3.
Yes.
We have green belt addressed in part by BNE5.
Yes.
And we have other open countryside policy BNE2. Right. And I just want to understand then the purpose of the settlement boundaries in the local plan. The purpose then of the settlement boundary, so far as Coppull perhaps is concerned, is to define an interface or boundary between the urban area, safeguarded land and green belt, isn't it? Yes. And so these settlement boundaries have two purposes. Firstly, to define an area, the urban area, inside of which housing is in principle acceptable to meet the requirements of the RS core strategy. And the second purpose is to define an area outside of which housing is in principle restricted because it's not required at this time to meet the requirements of the regional spatial strategy, joint core strategy housing requirement. And so then if I ask you to turn please to then policy BNE3 on page 47. And BNE 3.6, Blainscough Hall, what it's telling us is that it should not be consented at this time, pending a review of the local plan, because it was not required to meet the housing requirements in the joint core strategy, regional spatial strategy, correct? Yes. And so the effect, we can agree, of the safeguarded land and green belt policies is to restrict development to an area based on meeting out-of-date housing requirements in the regional spatial strategy and the joint core strategy, isn't it?
But I don't think those housing requirements are out of date following 2017 SMAR, or Strategic Housing Market Assessment, which informed MOU1, because that confirmed that the figures that we had, the 417 to which you refer per year, was correct. So I would argue that no, that the policy that stands today on safeguarded land is still relevant based on the fact that the housing need has been assessed more recently, and it's found to be very similar, obviously, to those figures. I accept they were done many, many years ago, but they've been reviewed more recently.
Okay, let me ask my question again without the offending use of the word out of date. We can agree, and I think you do agree, that the effect of the safeguarded land and green belt policies is to restrict development to an area based on meeting the housing requirements of the RSJCS. Right. And what we can agree is the joint core strategy housing requirement then is based on demographic household projections, which are significantly out of date from the period 1998 to 2003, aren't they?
Again, I'll give the same answer as I gave just a moment or two ago. Those figures are significantly old, but in terms of the numbers, they've been reviewed since.
Okay, old but reviewed.
And found to be correct.
Well, we'll look at exactly what the review did in a moment. They're based on a PPS3 methodology, which the courts have held cannot lawfully be a proxy for an objective assessment of need, correct?
Sorry, the courts have held to be, sorry, correct, go on. Yes.
Yeah, I mean,
Sorry, yes, no, you're right, sorry, I was just
yeah.
going through the question.
Yeah, based on a PPS3 methodology, which the courts have held cannot lawfully be a proxy for an objective assessment of need. Based on a regional spatial strategy, which has been revoked, correct?
Yes.
Based on a PPS and RS, which has been revoked and replaced by the NPPF in 2012, which has itself been revoked and replaced by the NPPF 2018.
Correct.
And based on an RS plan period of 2001 to 2021, which is time expired. And if I just invite you to look at CD 9.21, please. And I'm very mindful that I shouldn't cross-examine you on the law, and I'm not going to, but I'm going to explain a footnote in one of the decision letters. If at any stage you feel uncomfortable, you must say, and I take it, of course, that Mr. Ponter will be making your legal submissions, not you.
Okay.
Yes, that's entirely correct. Can I just add a word of caution, madam? Because if a proposition of law is going to be put, that is effectively cross-examining my witness on a point of law. Agreement is going to be invited, and that wouldn't be appropriate for a professional witness, let alone a lay witness.
I'm happy for you to proceed, Mr. Canuck, but I think we'll just see how you phrase this and what the question is, and then I'm sure Mr. Ponter may interject anyway.
Yeah,
We'll just see how we go.
It's understood, but by the same token, if I don't give the witness an opportunity to know the points that I'll make, it becomes a bit difficult. But anyway, I think we're on the same page. Paragraph 63, please, on page 25. And if you look about 6 or 7 lines down, he says, he, the inspector, was clearly entitled to conclude that the weight to be given to the restrictive policies was reduced to the extent that they derived from settlement boundaries that in turn reflect out-of-date housing requirements. So if we just pause there, we agree the derivation of the settlement boundaries, don't we? Yeah. And we agree that the settlement boundaries are derived from housing requirements in the joint core strategy. And so I suppose I'm inviting your agreement. You may want to agree, disagree, or defer. I'm a little indifferent because it's there in black and white. But of course, you can conclude that settlement boundaries are out of date if they are based on out-of-date housing requirements. And that must follow as a matter of logic, mustn't it?
There's a logical, but I don't know the context of what's being argued there, or the basis for the figures being drawn, or anything, so I'm not going to comment on that for obvious reasons.
Okay. Well, I don't want to take you further, but I've put the point, Mr. Ponter's aware of it. Right. The RS housing requirement was 417 dwellings per annum, wasn't it?
Yes.
And the local housing need figure derived using the standard method is 537 dwellings per annum, isn't it?
Correct.
There's no doubt that the RS housing requirement is out of date and inconsistent with the local housing need figure.
No, again, we come back to the 2017 review, which found that those figures are not out of date and that they applied, and therefore we come back to the argument that's what we're using, that's why we rely on policy 4, because those figures still apply.
Just think about the chronology, because the review process, which culminated in MOU 1, culminated in October 2017.
Yes.
An NPPF and local housing need came in NPPF 2018.
Yes.
So the review predates the NPPF.
Absolutely.
Right.
But the number, sorry, just
yeah. Well, let me ask my question again. There's no doubt that the RS housing requirement of 417 is out of date and inconsistent with the local housing need figure of 537 dwellings per annum, is there?
I'll say one thing, it is different from the local housing need figure. I would not say it's 417 is out of date. It is not out of date.
It's plainly inconsistent with the local housing need figure.
It is inconsistent, that's what I say, it is different. And of course, just to finish on that point, we would argue that the standard method can only be applied with a redistribution, which would be less than the 417 that we're currently applying. So yes, it is different.
Okay. And so even on your answers, the area of safeguarded land is based on a housing requirement, which is inconsistent with the NPPF.
It's inconsistent with the NPPF, yeah. In terms of the numbers.
Yeah.
Yes.
And so regardless then, because I haven't asked you a single question about whether there's a 5-year supply, regardless of whether there's a 5-year supply, BNE 3 must, I say out of date, but you accept inconsistent, because it's restricting development to meet a housing requirement, which is inconsistent with up-to-date policy. That follows from your answers, doesn't it?
It's inconsistent, but we don't believe it's out of date.
The second Pear Tree Lane decision, CD 9.1. Because none of this should be controversial. So you went through this in chief, CD 9.1, dated 11th of August 2020. And I'm going to take you, please, to paragraph 48. Am I in the right this here? Yeah, so paragraph 48. He's looking, the inspector, at policy BNE3, correct?
Yes.
And it effectively defines the settlement boundary, isn't it? And it constrained the development of the appeal site within the current plan period in order to offer long-term protection of the greenbelt, correct? And that approach was found to be consistent with national policy, wasn't it? Yeah. And it says, whilst consistent, the boundaries of the safeguarded land and thereby the adjoining settlement boundaries are predicated on a housing requirement on the central Lancs core strategy, which is out of date. And it was the inspector, if you look at paragraph 49, says case law has confirmed that settlement boundaries may be out of date to the extent that they derive from out-of-date housing requirements constraining the ability to meet housing needs. And if you look at footnote 34, that's the reference to which we just looked. Yeah. Right. Now, I think that you agree with me. We'll come on to whether the housing requirement is out of date. But just on the hypothesis, if policy BNE3 is based on an out-of-date housing requirement, then again, it as a policy must be out of date, mustn't it?
If it was based on an out-of-date requirement.
Yeah.
Yeah, I mean, yeah, it would be if the requirement was out of date.
Yeah.
But the issue here with Pear Tree Lane, of course, was a different. We were arguing with MOU2 there, and the numbers were derived. The housing requirement was derived from that, which of course was ruled not to be appropriate, not to be used. So of course we failed for that reason, and therefore you can argue the issue of being out of date. But of course that's not what we're arguing here, is it?
You see, I want to be clear, because this is a part of our case that you've not addressed thus far. That conclusion of out of date, that conclusion of inconsistency, can be reached regardless of whether there's a 5-year land supply or not, can't it?
Well, you have to explain that further, because my view of the fact that if the housing need is being met, that you have to determine the need. And the need is therefore based on which you are using, whether it's a standard method or policy 4. Now, if we're saying it's policy 4 and we win the case, then clearly all these policies are equally relevant. Now, we're still saying BNE3 applies, even if we lose the 5-year supply argument, because we're arguing that that safeguarded land adopted in the local plan still applies, and therefore the issue about the green belt still applies.
Let's look at it. Let's look at it this way. Turn please to the NPPF, paragraph 74, because your apparent response is to continually come back to the review. And paragraph 74 relates to the calculate. Sorry,
Find the end, it's not
CD 5.1, I think it was.
5.
Right, so 74 is referring to the calculation of 5-year land supply, isn't it? And footnote 39 is talking about a review for the purpose of a 5-year housing land supply calculation, isn't it? And so the sole consequence of the review relates to the calculation of 5-year housing land supply for the purposes of footnote 39, doesn't it?
Yes.
Right. Now, I just want to think about this. The conclusions that we have reached do not change simply because there's been a review. Let's go through them. Okay, I understand that there was a review in 2017, but RS has still been revoked, hasn't it? PPS 3 has still been revoked and still can't be a proxy for an OAN, can it?
No.
The demographic evidence 1998 to 2003 is still out of date, isn't it?
Yes.
The RS period is still time expired, isn't it? So regardless of whether there's been a review for the purpose of the basis of the 5-year housing land supply calculation, it doesn't change the conclusion that BNE3 is based on an out-of-date housing requirement, which you agree is inconsistent with the framework, does it?
No, but it still exists, so it still applies, doesn't it? BNE3 still applies.
So is that yes, but it still applies? Because I agree it still applies.
It still applies.
So it's a yes, but it still applies. I understood that correctly.
Yeah.
Thank you. Right. Because if we then think about section 38.6 and compliance with the development plan, we agree the proposal complies with the joint core strategy, don't we?
Yes.
We agree there's conflict with policy BNE3, don't we? We agree that's the sole policy of alleged conflict, don't we?
Yes.
We need to consider then any conflict against material considerations in the application of section 38.6, don't we? And when you consider any such conflict, if it's based on an out-of-date housing requirement, that must be relevant to the weight to be attached to any such conflict, mustn't it?
You'd have to consider it, yes.
Yeah. And if, as we've agreed now, right. So I then want to think further, because I've looked at you with the basis of BNE3. I want to look next at the weight to be attached to any conflict with BNE3, because I want to test the consequences of any policy conflict with it. And if I turn, please, to your proof of evidence, because you identify concerns which affect the weight to be attached to the policy conflict. We've looked at them briefly before. 3.1, first of all, and it's the second 3.1. It is, ma'am. Thank you. I was just getting a bit lost there. Right. So let's just identify these points again. So your first concern at 3.1 is applications and appeals being considered in isolation, correct?
Yes.
Right. Next, you say there should be a site identification and selection process through a local plan review, don't you?
Yes.
You say that it's the same point, the process should be plan-led, yeah? And you're concerned that this appeal could undermine the plan-led process, aren't you? Right. So that's the second point. And then the third point, as we've looked at before, is you say pressure on the greenbelt will increase through the plan process. Yeah. And if I look at your 331, sorry, we've done this just before, but I want these points fresh in your mind. 331 is the need for greenbelt release. We see the same points. 333, you say the plan process is at risk of being seriously undermined, don't you?
Yes.
334, you say there's a limited number of sites suitable for development outside the greenbelt, and they're essentially safeguarded land.
Yes.
Yeah. And then at 335, you're concerned again about increased pressure on the greenbelt.
Yes.
Right. Now, can I just be clear then, when I'm trying to understand any harm attributable to conflict with BNE3, those are the 3 points you want the inspector to consider and nothing else?
Absolutely.
Nothing else, right, because I'm going to then take you to them. The first then is decisions taken in isolation. Right, firstly, we can agree that Chorley has not asked the Secretary of State to call in any and all appeals into safeguarded land in Chorley, has it?
Sorry to just pause on that, Mr. Connect, for me. We have actually recently contacted the Secretary of State about the number of appeals of recent time following Pear Tree Lane 2.
Right.
If I can reference Pear Tree Lane 2 as such, because we are very, very concerned with the direction of travel, obviously, but more importantly, with some sort of inconsistencies, and we've sought clarity over that. And actually, that letter from the leader of the council did ask for these decisions to be called in.
Right. Okay.
Now that might be, and I'd have to clarify. And I apologise for the top.
Well,
of my
it's a
head.
matter of fact, and
It's a matter of fact. That's
if
what
you
we've
want to
done.
provide it outside the inquiry.
But all I mean by that is it may not be that it was an inquiry in Chorley that was asked to be called in. It may be in reference to Cardwell Farm and Chain House Lane.
Yeah,
Following
and
the two different decisions that we asked for that to be reviewed by the Secretary of State. That has definitely gone. And that's been done.
Let me put it another way. Preston recently had, I think, 7 appeals in and around Goosner, didn't they?
That's right.
And so they wrote to the planning inspector and said, can we have them all conjoined? Because they were concerned about cumulative impact.
That's right.
I don't think that Chorley have asked the planning inspectorate to conjoin any appeals, have they?
Well, the last 2 are obviously conjoined. Obviously, 2 at Town Lane and Tinkers Lane, but beyond that, no.
No. But if that were to happen, there'd be no conceivable concern about decisions being taken in isolation, would there?
In theory, I suppose that would alleviate that particular point if they were all taken at the same time. But obviously that requires applications all at the same time, doesn't it? And then joint, or not at the same time, but within a similar period, and then joint appeals. Okay. But I don't think we're in that space.
No. Regardless, of course, once a decision is taken, it becomes a material consideration in the determination of subsequent applications and appeals, doesn't it? And so if there is any cumulative impact, it can be taken fully into account in the subsequent decisions, can't it?
Not necessarily, because if you're doing one at a time, obviously the impact of one site being brought forward now, of safeguarded land, isn't as great as 8, 9, 10 sites being brought forward. Each would obviously still be argued on their merits.
Sorry, Councillor, that simply doesn't make any sense. If I've consented one site, and then I've got a second site that's before me, I can take into account the cumulative impact of site 1 and 2 in the determination of site 2.
I apologize. I thought you meant all the safeguarded sites we were talking about. I can join the appeal of all before. Well, that's what I understood your question to be. So I thought when you said that, you meant not all of them. What you're saying is, yes, of course, you can take one in respect of the previous one. Of course you can.
But beyond a generalised concern about impact to the plan process and a generalised concern about greenbelt release, you don't raise any tangible cumulative impact at all, do you?
No, but the issue is the impact on the greenbelt in the next plan process,
right?
Which we think is a significant concern,
right? So the
Can I
second,
just interrupt, Mr. Connect? By no tangible cumulative impact, are you saying that there are no figures or statistics within council's evidence to substantiate substantiate that potential implication?
Well, it's not, for example, a cumulative landscape point or a cumulative highways point or a cumulative infrastructure point. It's nothing. It's just a generalized concern that there will be this harm to the greenbelt. Sites will be released from the greenbelt, while there is this harm to the planned process. That's the most analysis that we get from the councillor's evidence. And I think we've agreed that, which, dare I say it, Mark, means I can sort of leave this point about decisions taken in isolation and focus on the next 2 points. Is that fair, Councillor?
That's fair. It is a logical conclusion that if there is no other land available, greenbelt land comes up for development, and the less land there is now, the more greenbelt we have to use in the future.
Right. So I want to then ask you about this second point, harm to the plan-led process. And we can be more precise about your concerns at 333, because your concern relates to the approach to establishing future housing requirements, firstly, doesn't it? And secondly, to the distribution of such housing requirements. Yeah?
Yes.
I don't think you articulate anything else, do you?
No, it speaks for itself.
Now, in terms of prematurity, and back to your 3.1 on page 10, you accept that there is an express policy on harm to the emerging plan process, don't you?
Yes.
You don't address it in your evidence, do you?
No.
But you do concede expressly that there's no prematurity point, do you?
No, that's right.
And to be clear, no prematurity point in respect of either an emerging neighbourhood development plan or the emerging Chorley local plan, correct? And so your evidence is concerned with a species of harm to the plan-led process, which is not a prematurity point. Yeah. Let's see if we can identify what that could be. Let's look, please, at the framework. Hopefully you've still got it open. CD 5.1 on paragraph 47. Paragraph 47 is dealing with determining applications, and then paragraph 49 is dealing with prematurity. And we can agree that arguments that an application is premature are unlikely to justify a refusal unless both A and B are met, correct? Yes. And we agree at the very least that B is not met, don't we?
Yes.
And if I look at paragraph 50, the plan has not been submitted for examination, is it?
No.
Right. And even then, a local authority would need to indicate how the grant of consent would prejudice the outcome of the plan-making process, wouldn't it? Right. So even when the issues in 49A are engaged, there's no basis for refusal here on the grounds that the emerging local plan process will be undermined, is there?
No, it's slightly different. This is about prematurity, isn't it? We're not arguing the premature argument. We're arguing that this would undermine a plan-led process, which would make for good, a good plan-led process, rather, which allows for better decision-making after it's been thought through and all sites are considered. What we're saying is this process now, and dealing with these appeals now in this way, undermines the approach to how are we going to ensure that Chorley has enough land for development in the future, how much greenbelt land may that require, and what other sites potentially can come forward. And that's to be done with through consultation with the wider public, not just in relation to one specific site. So the reason we're not arguing prematurity is for the reasons you quite rightly point out, that wouldn't stand up. What we're arguing is that there's a broader policy dimension to the council's position now, which is being affected by the potential adoption of a solar standard method, meaning that we need to require more houses than we currently say we do.
Well, Councillor, just so that you're clear, I don't accept that. And the point that I'm just trying to test with you at the moment is whether, in fact, the points that you're making fall squarely within paragraph 49A. So if you'll just permit me for a moment, we'll go through 49A. Because if I look at 49A, it says that the development proposed is so substantial, or its cumulative effect would be so significant, that to grant permission would undermine the plan making process. Pause there. You're not arguing that this development is in isolation so substantial it would undermine the plan making process, are you?
In isolation, no.
Right. But you do raise an issue about cumulative effect. We've just looked at it. Yeah.
Correct.
And it's addressed by paragraph 49A, isn't it? The development proposed is so substantial or its cumulative effect would be so significant that to grant permission would undermine the plan making process. That's precisely the point you've just been making to the inspector, isn't it? Right. And then in terms of the next point, by predetermining issues about the scale, location or phasing of new development, if you just come back to what you were telling us in your 333, do you see that? Establishing the future housing requirements. That is a concern about the scale of overall housing development being predetermined, isn't it?
Yeah.
Right. So again, that's expressly caught by paragraph 49A as well, isn't it?
But just to take you back to 49, that's the argument for arguing an application is premature unless you meet the criteria of A and B. We are not arguing this application is premature, so I see this is irrelevant because if our argument was this is premature, then we need to tick the boxes of points A and B on paragraph 49. We are not arguing that case.
No.
So I don't need to tick those boxes.
Right. I hear that. My point is you are raising prematurity argument, that you're doing it without applying relevant national
Well,
policy.
I fundamentally disagree with that.
And that's fine, and we'll make submissions on that. But just in terms of your final point, which is distribution or location in 333, well, 49A concerns the location of new development, doesn't it? That's the same as distribution.
Yes, it does, but as I say, I don't see that it applies because we're not forwarding that argument.
Right. So your concerns are expressly captured by paragraph 49A, aren't they?
No.
Sorry,
Well, yes, sorry.
Councillor,
My concerns of the cumulative effect of bringing forward safeguarded land now and the damage that would cause to the green belt. That's my concern. Now, if that is what you were saying 49A says, although I think it's slightly different, then that is the case.
Right.
But I'm making my point clearly. I'm not being quoted on paragraph 49A. I'm being quoted on what I've said in my proof of evidence.
Fine. But given there's an express NPPF policy addressing your express concerns, and given you accept that there is no conflict with that policy, no material weight can attach to your concerns about harm to the plan-led system, can they?
Yes, it can. Yes, it can, because the plan-led, as we know, the government's in their guidance says that the plan-led system is the best way to bring forward future housing sites, and that's what we are trying to consider. If we undermine that in the short term, which is what I believe we are if these sites are given approval, then that undermines the plan-led process. At the end of the day, we will have to public has to have confidence in the planning system and in the plan process, that when we go out to the consults, they get the opportunity to have an informed conversation about where is developed and what's suitable in the future. This undercuts that.
Right. Difference between us, we say squarely caught by paragraph 49. You don't accept that matter for the inspector. I'm not going to keep putting the same points. But I want to just consider the points in just a little bit more detail outside paragraph 49 because you claim it to be a freestanding point. So the first point is scale of housing development. Now, just turn please to paragraph 61 of the NPPF. Because the process that the HMA authorities or CBC alone will follow is set out in paragraph 61 in terms of resolving the scale of housing development, isn't it? Right. And so the approach to establishing future housing requirements is set out in local housing need and the standard method, isn't it?
It's paragraph 61, yes, it is.
Yeah, plus any unmet needs from outside the area. Yeah?
Yeah.
So a decision on this appeal will have no impact on Chorley's future housing requirement at all, will it? Because it's resolved by local housing need and the standard method.
No, but that's the apple. We're arguing that it shouldn't be using the standard method because we're saying that this policy 4 still applies on the basis that standard method without the redistribution is not the correct way of, or not a fair way, as it were, of assessing Chorley's future need. Because, of course, I don't want to go into a different argument we've not gone on to yet, but about this fact that we've supplied so many houses over the planned period, which, of course, was predicted that we would deliver more in the early part and then it would dip towards the end. So we have met our housing need, and that's why we argue for policy 4 and not the standard method.
No, Councillor, you're not quite getting your ducks in a row here. Go back to your 333 on page 16. So the point that you're making here is harm to the plan-led system. Yep. So the review doesn't get you out of this because we're talking about the next plan.
Yeah.
Okay, so...
Sorry, yeah, go.
Right.
Yeah.
And the point that you're making is there'll be harm to the plan-led system because it will prejudge effectively the scale of housing development. Now, what I've just put to you and you've agreed is that in the next plan period, the scale of housing development will be established through local housing need and the standard method, won't it?
We'll start with the standard method, yes.
Right.
Yes.
So it follows that a decision whether to grant consent on this site will have no impact on CBC's future housing requirement through the next plan, because that is resolved through local housing need.
Yes,
correct?
Yeah.
Right. So can we agree then that there is no prejudice to the plan process due to the scale of housing development on that basis?
Purely on the numbers, yes.
Yeah.
Yeah, fine.
And so your next point then is the location of housing development. I mean, just on that, this appeal site has been specifically designated to meet development needs, hasn't it, over a 25-year period?
In a future development needs.
Yeah. Now, save for the requirement for a local plan review, this authority accepts development of this site would be sustainable development, doesn't it?
Yes.
Right. And at 334, you're expressly telling me that there are a limited number of suitable sites in Chorley outside the Greenbelt, aren't you?
That's right.
And you accept that such sites are on safeguarded land.
Yes.
And to be fair, that's not a surprise, is it? Because that's been a planned outcome since at least 1997.
Correct.
And so it's inevitable, isn't it, that safeguarded land sites will be required in the next plan period as specifically conceived by previous plans.
That's right. It's a strong possibility, but only after that review is conducted, though. I must go back to that point.
And if one looks next, please, at CD 6.5, the issues and options paper. You have it?
I have it, yes.
Yeah.
Thanks.
And can you find, please, it's not easy, paragraph 812, I think it's on page 48 of 76, or 50 of 76, please, 812.
Bear with me a minute. My system has just crashed. I've got to load it again. The document there. CD 6.5.
And so paragraph 812, I'm on page 50. And so what the local authority has done to date, although in fairness, I think that this is the HMA authorities have done to date. I don't want to sort of personalise it to Chorley. But they've undertaken 2 call for sites exercises to identify potential new areas for development.
Yes.
And at 813, we see that almost 500 sites have been submitted through the call for sites exercise, haven't they?
Yes.
And then a further 200 have been put forward by councils, haven't they?
That's correct.
And all of those sites have been put through a SHELAR process, haven't they?
Yes.
You see that at 814. And then what one sees at 8:22 on the next page, we see that elected members from Chorley have been consulted, as have parish councils as well.
Yes.
And we know that there's no objection to the allocation of this site from Coppull Parish Council, is there?
No.
Now, what we know through this application process is it's been the subject of consultation, hasn't it?
It has.
Those consultation responses have been the subject of detailed consideration by this local planning authority, hasn't it?
Yes.
And in the light of those consultation responses, the LPA has no objection to the principle of development subject to a plan review process, correct?
Correct.
But you don't tell me what on earth may emerge through a plan process which impacts on the principle of development on this site that hasn't emerged through consultation on the application process, do you?
There's nothing in my evidence, but that's because we're at the, as you said yourself, we're at the early stage of the new local plan. There are many more phases to go, and of course I don't want to predetermine the outcome of that.
Well, but that's an analysis that pulls itself up by its own bootstraps. You provide no evidence as to why, given the agreement between the authority and the developer on the principle of development, the site should not be allocated, or why that might not happen, do you?
Yeah, I can't say it won't.
No.
That's exactly, and I would do if it wouldn't be. But that's the point. We're in an early stage of a plan. I can't say what the outcome of that plan will be.
Thank you. Right. And then the third point that you take, please, is harm to the greenbelt. Now, the LDS proposes adoption of a new plan by 2023, as we've looked at, doesn't it?
Yes.
CD 6.5, so this is dated November 2019, and if we just look at it, the forward on page 5, please.
Same document.
Same
Yes.
document, please, yeah. The forward on page 5. It's looking to shape the future over the next 15-year period,
Yes.
isn't it? And if one looks at page 11, we've got the vision and objectives. Yeah. Paragraph 16, again, we see looking over a 15-year period to 2036, we see in the next paragraph, don't we? Yeah. And again, it's a matter of common ground. We've looked at it, that the plan period is 2021 to 2036, isn't it?
Yeah.
Right. And if I look at that in this document, 3.4, please, on internal page 17. We're looking at the number of homes. Sorry, do you have it? So right-hand column, 3.4.
Yes. Yes.
It's likely that the number of homes we must deliver for this plan period of 2021 to 2036 will be different to our existing policy. Do you see that? And what one sees at 3.6 on the next page is over that 15-year period of 2021 to 2036 is 15,495, correct? Correct. Right. So we're already in the next plan period.
Yes. In the, yeah, sorry, 2021.
Yeah. And nowhere in your evidence do you grapple with that point, do you?
But we're still obviously at the before the adoption of this plan. We're still in this period, aren't we? We've still got the existing plan. It's our only documents, isn't it, in terms of the housing delivery and the numbers.
Sorry, just come back to my question. Nowhere in your written evidence do you grapple with the proposition that the next local plan period is 2021 to 2036,
No,
do you?
no.
And I just want to understand what your concern is about pressure on the greenbelt, because the next plan must establish a base date for the purposes of assessment.
Absolutely.
Right. And at the moment, the base date is 2021 because we're looking 2021 to 2036, correct?
Yes.
Right. And the appeal site in this issues and options is proposed to be allocated.
Yes.
But it doesn't have planning permission.
Correct.
Right. Now, in the future plan preparation, if planning permission is granted, well, sorry, in the future of the plan preparation, the difference is either this site is an allocation with planning permission or an allocation without planning permission.
Yes.
Right. But either way, it would count towards the local authority's forward supply to meet the housing requirement derived through the local housing need and standard method, wouldn't it?
It would.
Right. So what I'm trying to understand then is whether, as we've agreed, it's an allocation with planning permission or an allocation without planning permission, there's no implications for the release of Greenbelt at all, is there?
Well, the logic of what I'm trying to say is that if it is, you're absolutely right. If it's allocated now, so as it were, if this appeal is lost and the planning permission is given, that is another site which has already been taken in this plan period. Now, the next plan period may start from 2021, but that would still affect the Greenbelt release because there'd be less land available to actually build on to be included in that period. So, for example, we had the debate earlier this afternoon about whether this is brought forward in 2021 or 2026 or later. Now, if it was brought forward later, that would be included in our numbers in the new plan that's not included now.
Sorry,
depending on when permission is given. So I'm basing it now, if it's refused today, then this could be taken forward and delivered at a later stage. So that does impact on the amount of Greenbelt land that you potentially may have to use in the future.
Right. Let's just take it in stages, because respectfully, that's not right. Okay. We have a plan period agreed in the Statement of Common Ground, 2021 to 2036.
Yes.
We're agreed we're within that plan period. Right. Assume, as is the current position, the site is an allocation without planning permission. Yes. It would then contribute to the forward supply, wouldn't it? In that plan period. Assume next that planning permission is granted. It then becomes an allocation with planning permission, and it will contribute to the forward supply within the period 2021 to 2036 in precisely the same way, won't it?
It would. But that's just one little caveat, which I did make earlier, and I'll make it again. I accept it's in the plan now. I accept it's down for designation, but we've not gone through the plan process. That could, in theory, change, and that would be predetermining the local plan that's due to be undertaken.
Right.
So I accept your logic of a numbers game.
Well, that's.
But I don't accept the logic that we're here, that a decision now won't have an impact in the future, because it will, because we're predetermining the outcome of a local plan.
So I've got the clear answer, it would. And if, as an allocation with planning permission, it would make a contribution to the forward supply 2021 to 2036, it follows that the grant of the consent has no implications for the release of Greenbelt, does it?
But it would have an implication for Greenbelt, whether it's done now or later. So I come back to the original point you make. If we approve it now, that goes towards the figures for the future. That then means that more land has to be made available that currently isn't available in the next plan period. So actually, I'll reverse the argument. I don't think it's a question of whether it's refused or not. This is going to have an impact on the Greenbelt at some point in the future. That is just a matter of fact. You can't use up all the land. So again, to flip the logic of what's being said or what's being put to me, that if this land is used and permission is given, that then when we need to meet our future requirement, what land do we find? Automatically, that has to be Greenbelt land.
Right.
So approving this does have an impact on the Greenbelt.
Okay. So let's just move forward on the basis of our agreement that with planning permission, it would make a contribution to the forward supply in the next plan period. Right. The process is quite straightforward, Councillor. In the next plan period, 2021 to 2036, firstly, the authority must resolve its housing requirement, mustn't it?
Yes.
And then it must establish its supply, mustn't it?
Yes.
Right. And if it cannot meet its housing requirement on sites outside the Greenbelt, it must then consider exceptional circumstances, correct?
Yes.
Right. Now, as to that issue of trying to establish its supply outside the Greenbelt, we've agreed the contribution to the supply is the same whether or not it has consent, correct?
Yes.
Right. So it follows then inexorably that But whatever that supply may be, it's going to take into account the appeal side before we get to greenbelt sites, isn't it?
Yes.
And it follows then that there are no implications, no increased pressure on greenbelt, because whether it has planning permission or doesn't have planning permission, you've agreed it contributes to the forward supply. That must follow, mustn't it? Ma'am, I'm mindful of the time. I'm going to leave those points and move on to the two issues which are between us in terms of housing land supply. There are 2 points. There's the housing requirement, there's the oversupply point. I'm happy to continue. I think in fairness, we've made reasonable progress today. I'm entirely in your hands, but I think in a sense, if I'm going to start, I'd like to complete.
How much time do you think you'll need if you're going to start now?
Well, I mean, we're certainly more than halfway through, ma'am. I think, I'm not quite sure how long I've been. I'm going to need more than 20 minutes.
Right, okay, that's fair enough. What I think would be most appropriate then is if we actually adjourn for today and then come back in the morning.
Yes.
I'll continue with your cross-examination then. Okay, so just to remind the witness, of course, you will still be effectively in purdah and you cannot discuss matters with your advocate or your team, I'm afraid. So thank you very much everyone for today. We will adjourn then till tomorrow till 9:30 when we'll continue with the cross-examination. Thank you very much everybody.
Thank you.